Time being 8:40 a.m., we apologize for being a little late. It's a little chaotic around here. We will call this public hearing to order. And so I read the hearing announcement. Which is the hearing announcement? Sarah?
So Commissioner, that would be the,
Okay, perfect. So, this is a petition for Oceanside Incorporation, number 851-22-000224-PLNG. Petition for the incorporation of the unincorporated community of Oceanside and the creation of the city of Oceanside. Petition includes a new tax rate for properties within the proposed city limits of the city of Oceanside at 80 cents per $1,000, and that is in Exhibit B. So that's all I have to read. Okay, so this hearing is hereby opened. We're going to ask County Council to read our quasi-judicial hearing proceedings. Bill Sargent.
Thank you. The sign-up list is being circulated for those who wish to testify, and you need to provide your names and addresses so that we can get back to you. There are certain criteria that's ordinarily part of a land use proceeding like this, and this one's kind of unusual. But there are statutory references in ORS 240, and it looks to me like, I'll just quote from it, any person interested may appear and present oral or written objections to the granting of the petition, the forming of the proposed incorporated city, or the estimated rate of taxation. So the way I see it, those are the criteria for today's hearing. And if you do not discuss that criteria specifically, with specificity, you can't make an appeal to LUBA on that issue. The order presentation, the case has made a request for a continuance and some legal arguments, which I know the petitioners disagree with, and so today we'd like for those arguments to be made briefly before we get into the staff presentation. When that's done, the staff will summarize its position, and the commission may ask members, may ask the staff questions. Then the applicant can make its presentation, and we'll have public comment thereafter. And as you know, there's 3 hearings, so at the conclusion of today's hearing, it will simply be continued to the next date that's been noticed. First of all, is there a challenge to the jurisdiction of the board to hear the matter? Are there any conflicts of interest or personal biases that any commission member board would like to declare now?
no.
How about any ex parte contacts?
None.
All right, then that's all I have to say. Thank you.
Okay, Sarah.
Thank you, Commissioner. We do have some feedback from those participating online that they can't hear very well. So I'm going to try to turn that speaker up real quick and just ask if everyone can talk a little louder. Make sure your speakers.
So let's ask if that's any better for people online.
Any comments, Lynn?
You can hear
Okay.
Chris, so you can hear.
What does it say? I can't read
He
it.
said he can hear.
Okay, so I'm trying to get online and I cannot, so I don't know what the deal is here, but that's okay. Okay, so let's move on. So my next agenda item here says staff will request the case letter is discussed prior to proceeding with hearing for 2. Okay, so Sarah, you're going to talk about the new petition. Who's going to talk about the new petition that was issued this morning?
So Council, I've not had a chance to read it. Would you like to discuss the continuation request, or should we just recommend that we hear from both the...
I just thought we'd hear from the 2 sides, Dave,
Okay.
if you're ready to make your arguments about why you think the continuance ought to be granted, and we can get by that. I don't know that the decision will be made today, but at least we can set the record straight for your petition.
Excellent. For the record, Dave Phillips representing the Capes. Pleasure to be here and thank you. I hope the folks that are online can hear me okay.
Hold on just a moment, please. Okay, so everyone online, please, you need to remain muted. And I'll apologize for our situation this morning, but the Commissioners' Meeting Rooms A and B is no longer Commissioners' Meeting Rooms A and B. We've turned that into a new courtroom for Circuit Court. We are in an extremely small meeting space in the basement than a Halen room. And there's no way we could have more than 2 or 3 guests in that meeting room. So we're using this facility, and it's worked in the past for us. Not a great meeting room, but I think it's going to work. We're going to have to ask everyone please to speak up, because the speaker and microphone that we have doesn't work that well in a large room like this. But again, it's very important that people online, please, must remain muted unless you are called on and asked to speak. So sorry for that. Please go ahead.
Pleasure. I will make a point of speaking up as much as I can. County Council, thank you for the preliminaries to this proceeding, and I certainly do recognize that this is the first of 3 commissioner meetings in a quasi-judicial proceeding. I don't think there's any objection with recognizing that this is a quasi-judicial proceeding, and that although we are at the first of 3 scheduled hearings on all of the matters, and that the record would stay open, I do want to, as County Council has asked, present some procedural questions. Overall, I have 4 or 5 questions that I believe need to be answered in order for this petition to go forward. The first 3 are questions that are of procedure, and the second 2 are questions of substance. And so I'll start with the procedural questions, and hopefully we'll have some interaction and maybe some questions from the county or from council as well. And then I'll, as you mentioned, I will kind of keep my comments related to the substance of the petition for the public comment period. Is that okay with you, council? Thank you. So Matt Martin from my office is also appearing as co-counsel. He's not here today, but he is available on the phone to the extent there are any questions for him. The 3 procedural questions that I have relate to the proceedings that occurred before I was involved and became involved in this matter. And so I know you folks have been living with this for quite some period of time. I understand there were 3 hearings over a 6-month period, and although I've seen portions of that voluminous record, the outcome of that record was obvious in the fact that it resulted in a denial. And I understand from that record that the denial was based on substantial evidence, that the petitioners, or that the applicant in this case, was not able to present substantial evidence to support the correct, their position that they satisfied the elements of the test. And in this case, it boils down to, on the merits, whether or not proposed property will benefit from inclusion in the incorporated area. That's for the substance of the matter. I understand that your code, and I believe that your code requires that you dismiss the petition on its face. It's premature because it occurred far too soon after the denial that resulted from the previous proceedings. I'm citing 10-020 sub 6D, and that denial was not appealed. If it were somewhere in and along the appeal period through LUBA, obviously this is a land use decision, and the decision that you issued before, which was a denial, is also a land use decision. That decision appeal path would have been through LUBA and the Court of Appeals, potentially under cert to the Oregon Supreme Court. There were no appeals. That decision is final, and they needed to wait 6 months. And we assert that at best, for purposes of procedural clarity and the ability to also present the evidence that would allow this commission to evaluate the application on its face on the merits, that they needed to wait 6 months, otherwise the county cannot review it. This clearly is Article 10, and it governs, Article 10 of your code governs these kinds of proceedings. The Luba decision from 2018, Van Dyke v. Yamhill County, clearly shows that we have a quasi-judicial proceeding that, and I believe, in fact, that there were mentions during the previous proceedings that quasi-judicial was the proper application of the code type 3. In the alternative, if the county entertains going forward with the petition, recognizing that we do have future open record sessions and future hearings, that the case, and the best way to explain this is, again, I wasn't living with the previous application and I've only seen the record that was formed. The case was excluded, either intentionally or unintentionally, from the previous petition. And whether or not the case was excluded or included from the previous petition was a choice on the part of the petitioners. I understand that there might have been interest on the part of the commissioners to include the analysis to cover the case, but in order to expand the area of incorporation, there are a number of statewide planning goals that must be complied with, and I point to Goal 11 specifically, and that's on the merits of my discussion. The ask here today is for the commission to make a decision on a motion to dismiss. And in my opinion, asking the petitioners to come back in 6 months would allow them and the case the best opportunity to evaluate this application on the merits. Second, and this is a certainly standard procedure in land use proceedings, although we have 3 hearings, they're somewhat compressed. And from my view of the previous record, I saw none, no evidence whatsoever presented by a land use practitioner of a professional sense. I have, my clients have hired AKS Engineering, who have a professional land use planner. Mimi Dukas has a letter that we submitted into the record. She believes that she is the right, has the right kind of professional background to study the proposed inclusion area. And she might also need evidence from an economist to evaluate that economic question as to whether or not the city, once formed, would have the right kinds of funding sources. And again, that gets back to the overall question on the merits, is whether or not they're actually providing additional benefits to any of the included area in the first place. I understand there are 400 pages of the previous record that I need the time to parse through and respond to, if this commission were to include that previous record into this current proceeding. And that's another basis for my request for continuance. Most importantly, related to that previous record, I understand there were stipulations between the applicants and the county related to both procedural and substantive questions. I wasn't present, my clients weren't present, and that decision, which was a denial, obviated any of those stipulations or any of those findings. Those findings were not adopted by that previous application, and because the application was denied, they have no force going forward. With that, I think I'll wait for substantive questions on the hearing record for a little bit. If you have questions for me, please interrupt me at any point, or we can go back and forth. Thank you very much, Commissioner, County Council.
Yeah, thank you for that. So at this point, I think I'll ask the petitioners for a response to what we just heard.
Thank you, Commissioner. We submitted a written response to their written motion or request, which were subject to, I think, pretty much the same longer version of what was presented earlier today. So primarily we'll rely on the written response. So I think we did respond to most of the things that were mentioned. We would emphasize that the incorporation statute has its own timing and notice constraints and requirements, and comply with those. And to the extent they're inconsistent with the land use constraints that are timing limits and things that are being proposed would require dismissal, the corporation statute is obviously more specifically applicable to this proceeding than the general land use statutes. And generally in law, more specific statute controls over a water statute or a more general statute. And that's probably the only point that wasn't really made in our written materials. Anything else? In terms of whether or not the prior order incorporated stipulated findings, we think it did, and it did so on the face of the order. That was a negotiated agreement among us as the best way to proceed. It was basically an effort at collaboration and moving forward efficiently, fairly, and legally, and came to this proceeding expecting that it would be honored as a practical matter. Not as a legally binding matter, but just as a way to proceed. And then finally, I guess I would say that to the extent there's some idea that the Capes were new to any of these issues or any of these, or any opportunities to present these arguments, the Capes folks were involved in this whole initiative from the very beginning. They are members of the LMA. They do receive the LMA newsletter. They joined in droves during this debate. They opened their emails according to MailChimp data, and we're well aware of all of these things and only just decided to bring in counsel later, thinking that it wasn't necessary early on. Might have been a reasonable guess to make, but it doesn't take away from the fact that all of these issues and the potential outcomes were at play in the prior proceeding and continuing on to this proceeding. And the idea that really bringing in counsel this late, once time to study things, is contrary to the way the facts played out, and also not fair to the petitioners who are facing timelines, and the effect of the 3-month extension would essentially kill this petition, forcing things to not happen, an election not happen until 2024 because of the timing requirements of the incorporation statute. So it wouldn't just be a 3-month or a 6-month delay. It would be years. And that's all we have.
So,
May I, just a very brief rebuttal? I'm sorry to ask. And well pointed out, we have a little bit of on the record back and forth. There's only one statement that I'd like to make to clarify both my statements and the response. The proceeding that is open today under the land use laws of the state of Oregon is the only proceeding open at this time. The proceedings that occurred previously resulted in a denial. That record is closed. It was not appealed, and so we only have the record and the proceeding that is present at this time. And there is not rule of the law, case law, that could govern your going forward. This is a new proceeding on its own and would operate under the proceedings that you're controlled with current land use codes and the current organization of the land use planning goals under state law. I recognize there is a history here, and the petitioners have pointed that out, but none of that history binds you, is my conclusory statement. Thank you.
okay, so at this point, I'm just going to ask briefly if county council and or staff have any input at this point.
No, Dave. Other than I think procedurally it's best for the board to make a decision or postpone a decision till the next hearing, whatever you think is correct on the request that's been made by the Capes for a continuance and in effect the dismissal. So, and then we can move on from that, but I think the board should bandy that about a little bit and decide what you want to do with that issue before we, if we decided you wanted to dismiss, we can all go home.
Okay. Joel Stevens, Joel, are you online?
I am, Mr. Chair.
Any comments at all?
Just that I concur with Mr. Sargent. I mean, I think it is an issue before the board. The council's basically asking for two separate things to dismiss and then any alternative for a continuance. And so, I think it would be prudent for the board to look at those two things and address them. The dismissal it probably needs to be dealt with first, but then, the matter of a continuance, I think the board could look at that now, they could look at it later, depending on how the hearings go. I think that's up to the board, but I do think it would be prudent to, since this motion has been made, once the board has heard from both sides to their satisfaction, I think it would be prudent to have a discussion about it.
Any comments from staff?
Thank you, Chair. I'll just make a clarification, just for the record. The reference to the code in Article 10 is the Tillamook County Land Use Ordinance, for those who may not have been able to make that connection. Article 10 of the Tillamook County Land Use Ordinance for land use applications that the county reviews specifically states that those applications within the use table are subject to a 6-month waiting period if the initial application is denied. So that is only contained within Article 10 of the Land Use Ordinance, specific to applications that the county reviews.
And council, you had something?
Well, I was just going to say on the motion to dismiss, council and the petitioners submitted, a little bit of case law and statutory references, none of which either Joel or I have had the opportunity to brief the board on, and I think it's, put you in a tough spot, to try to interpret case law and statutory law here today when you haven't really had much of an opportunity for your counsel to get back with you about all of that. So, I recognize that's difficult, and if you need more time, Joel and I are certainly going to, we can weigh in too, but we haven't had that opportunity yet to do so.
Okay.
Anyway.
Okay. So Joel, would you agree with that?
I do, Mr. Chair. I think it's up to the board, how and when they want to proceed here. So, I'm happy to have a more substantive conversation right now. If the board feels they want to table this and move on to, the scheduled items, then, I think that's fine too.
Okay, so it would be, I am very reluctant to dismiss at this point or to continue the discussion, or excuse me, to offer a continuance until we get more information from county council on a way to move forward. So I'll ask the other two commissioners if they have any thoughts on this at all.
I would just say I agree. This is a very obviously legal proceeding, as all of these are, and there is a huge amount of case law that's been quoted here, and I think it's really important for us as we look at the position for everyone that we understand the decision we're making on that. So I don't think we should dismiss or continue at this time. We need to understand all of that, because it would be my understanding if we move ahead this morning, we hear the presentations, we hear public testimony, it allows us to continue forward, leaving both roads open into the future. We can dismiss or deny after having started, if I'm not mistaken, excuse me. So it just feels like leaves both roads open if we go ahead and let the folks who have spent their time to be here this morning share with us their thoughts and begin the process, knowing that, you know, pending legal counsel, we may then, you know, end up dismissing or extending. But those are my thoughts.
Thank you.
I agree. I'm disinclined to dismiss because I just received the petition today when I walked in this room. So I'm totally not prepared to make a decision on that.
Understood, absolutely. Okay. And same with county council.
Okay. So at this point, I think, so is the correct terminology, Bill, to table the motion to
Yeah.
dismiss or continue?
Yeah, you can bring it up at the next scheduled hearing.
Yeah. At that point, we'll hear from county council as to your thoughts on the direction that we might be able to take. But at this point, I think we're going to table this. So do we need a motion and a vote on tabling this? or
I
do
don't
we
think
just
we
move
need
on?
to really, just move on.
Okay, perfect. So let's just move on then. What is our next order of business here? I'll turn to staff. Perfect, great, perfect.
Thank you, Chair. Good morning. Again, for the record, my name is Sarah Ashram, the Director of the Sonoma County Department of Community Development. For you is a petition request for the incorporation of Oceanside. So the process, this is a quasi-judicial land use hearing proceeding that has been determined to be the appropriate hearing proceeding path because a petition decision is appealable to LUBA. Public hearing requirements, as stated in the staff report and reflected in the record. Public hearing requirements under ORS 221 have been met. These include publications in the newspaper record, which is the Tillamook County Headlight Herald. Community postings have also been completed throughout the area proposed for incorporation. The department did assist in putting those notices together so that the petitioners could post them at least 2 weeks prior to the first hearing. So all of that has been met. Also, as reflected in the record, the petitioners did go a step further and send out notification to all landowners within the proposed incorporation boundary. While this is a quasi-judicial hearing proceeding, the typical notification requirements for a quasi-judicial land use process are not required for this process. So final action by the Board of County Commissioners, which is the court, as identified in ORS 221, is a final action with an order and findings on the petition request. For determination by the Board of County Commissioners, first and foremost, is incorporation feasible? There's a lot of information in the record that talks about feasibility, and at the petitioner's request, the previous record has also been folded in and made part of this current record. Feasibility, including the economic feasibility study. Other criteria include consideration of objections to granting the petition, consideration of objections to formation of the incorporated city, and consideration of objections to the estimated tax rate, which is at 80 cents per thousand. The proposed map boundary with that is the determination of benefits. Moving forward, the petitioners have submitted a map that includes all properties within the unincorporated community boundary for Oceanside. The northerly region of that map has been extended to fully encompass and include properties that are bisected by the community boundary map. There are a couple, as you know, and you do have copies of the maps along with the map that identifies voter registration within that area. Previous discussions, the previous hearing proceedings, we spent a lot of time talking about benefits and who should be included or excluded and what properties may be denied a benefit. Is there a gain of benefits? The map as amended is a reflection of that conversation, most notably the inclusion of the caves. And that is largely due to concerns about sewer availability that would not be available if the Capes became excluded from a community growth boundary in a city. Goal 14 only allows sewer to properties within a city or state acknowledged unincorporated community. Economic feasibility study. The study that the petitioners have provided, and I'll go ahead and let them talk more about that during their presentation. Statute requires first and third year budget projections. The petitioners did include the second year within their projections, again with the proposed tax rate of 80 cents per thousand. Through the petitioner's report, you can see their efforts to consult with other municipalities of similar size and needs. With that, urban services. So what is unique about Oceanside is that they are served largely by special districts that also provide those services to other areas, including the unincorporated community of Netarps, which abuts this community to the south. There are statements from Director Chris Lady from Tillamook County Public Works with evaluation of the economic feasibility statement in relation to transportation and road services. There's also a comment in the record from County Treasurer Sean Blanchard about the economic feasibility study. It was called to our attention that there was a mathematical discrepancy. Sean and I met with the petitioners on Friday. That mathematical discrepancy has been addressed and resolved. County Treasurer Sean Blanchard is in another meeting at the moment, but will be happy to join us and answer any questions about that when she is able to join our hearing, and the petitioners will probably have more to say about that as well. Lastly, likely compliance with land use goals. So as we know, Oceanside has a community plan. That community plan is contained within the Goal 14 element of the Tillamook County Comprehensive Plan. Community plan essentially serves as a smaller comprehensive plan with an address of each of the statewide planning goals reflected and consistent with the county's overall comprehensive plan, and implementing ordinances unique to the community of Oceanside that reflect their policies and their aspirations contained within their own community plan. In my opinion, as the Director of Community Development and working with Oceanside and also in concert with the Oregon Department of Land Use, Conservation, and Development, it is highly likely that they will be able to comply with meeting their obligation to develop their own land use planning program consistent with the statewide planning goals. The petitioners will also be prepared to talk about that. So with that, transitioning into staff findings, the county clerk has confirmed, this is also in the record and in your hearing packet, that the petition requirements have been satisfied. As mentioned momentarily ago, the hearing notification requirements for ORS 221040 have been satisfied. We have the proposed city map boundary. At this juncture, if there are any concerns about that proposed map boundary in relation to benefits, again, to reiterate for the record, it is the court or the Board of County Commissioners that now has the authority to make modifications to that map in relation to benefits if the board feels it's appropriate. Comments from Director Chris Lady, County Treasurer Sean Blanchard, and also the short-term rental revenue data that is part of their economic feasibility study is contained within the record. In our meeting on Friday, we did have a conversation about transient lodging tax and short-term rental permit revenue projections, and did confirm that the projections contained within the record are correct. So Tom Steiger and Community Development did join us for that part of the meeting so we could talk about those projections. And then again, likely compliance with land use goals. The department does feel that it is likely that the city will be able to comply. Again, technical support and assistance during development of the comprehensive plan and implementing ordinances for Oceanside would be done in concert with the Department of Land Conservation Development, Community Development, and most likely the League of Oregon Cities. Municipal services, city would retain their own planning services. Again, special districts already serve for water and sewer. They do have funding reflected in the petition's report for staffing, for services, and then as with the other incorporated cities in the county, the discussion is another IGA so that community development would continue to provide services for their building program. And that is all I have. Thank you.
Thank you.
Thank you, Sarah. Where are we going next?
Well, if you have any questions for me, I'm happy to answer them. Director Leahy is also on the meeting. As I mentioned, Sean Blanchard will be joining us, as well as Tassie Mill County Clerk, who is in the same meeting with the treasurer. So we can wait, or I'm happy to answer any questions now, or you could move on to the petitioner's presentation.
So I do have a couple questions. So as far as life health safety, the Oceanside Neatards Fire District, I'm not sure exactly what they're called, they will continue to provide emergency services, fire protection, things of that nature. As far as public safety, my understanding that they would just rely on the Tillamook County Sheriff's Office, is that correct?
I would let the petitioners, Chair Yamamoto, further detail that. But yes, initially that is my understanding, along with several of the other cities that also rely on the Sheriff's Office for the services through IGA.
Okay. And as far as city-style services like planning, permits, things of that nature, inspections of buildings, that would continue, at least we think it will continue with community development. Is that correct?
So yes, that is correct, Chair Yamamoto, with one delineating factor. The city will retain its own planning program and have a part-time FTE planning service, like the city of Rockaway, Garibaldi, and others. Those zoning permits, et cetera, would be provided to community development with the building permit application submittal. So we know that work is done. And then we proceed with the building permit plan review, subsequent inspections, et cetera.
So if this continues to move forward, if indeed they take this to the voters, if indeed it is passed by the voters, their initial ONA community plan that was developed and is part of the county comprehensive plan, that would be their starting point, am I correct? And then from there, they would have a planning commission that would make any changes that they wanted to. And one more question, if indeed an Oceanside Planning Commission wanted changes to the city comprehensive plan, and that comprehensive plan would still have to be filed with the county? Sorry, lots of questions.
No, that's okay. These are great questions.
But then that would also come back to community development for approval. How does that whole thing work?
Sure, happy to answer that. Those are excellent questions, thank you. So if the petition moves forward and is passed by the voters, current regulations remain in place until the city is finished with their own comprehensive plan and ordinances that are adopted and acknowledged by the Department of Land Conservation and Development.
So again, to begin with, they would use what's in the county comprehensive plan, which is their ONA community.
Correct.
Okay.
And essentially, then they have a blank slate to create their own comprehensive plan and own implementing ordinances. But they have to comply with statewide planning goals.
The 19.
That's right. So they will use what they have until their new program is developed and acknowledged and adopted. But during that transitionary period, the department would continue to provide those services. We would be a partner to provide technical assistance in helping them develop their own comprehensive plan and ordinances where needed. Largely, that is something that the city would do independently with DLCD and their own consulting firm that they would hire.
So as they, just coming from a comment that I received in my email, do the the CCR&Rs of the existing community stand, are those protected? Or can the city come in and say, well, now you're part of our city, we're going to make you change how you've developed your community? Can you tell me how those two play together? And
Sure. So I'm not an attorney, just not going to give you legal advice.
But in terms of a land use process, right?
And don't ask me.
Okay, in terms of a land use,
Yeah, so CCNRs, the department does not enforce CCNRs for any development.
Okay.
CCNRs are separate and independent of land use regulations.
Okay,
So arbitrarily, if ordinances change, CCNRs do not.
Okay.
But the catch always is, you have to comply with both.
okay.
So whatever the city would choose to do, a landowner developing in a development with CCNRs would be required to meet, to satisfy. And typically, the more restrictive applies.
Right, thank you.
Okay, I think they're good. Questions?
I do have another question.
Sure.
And this, I want to just go back and clarify the sewer piece of this. Because again, in comments received for many people, they seem to feel, there are some who feel that that is not accurate. So can you describe why it is, and I understand you stated very just quickly, goal 14 that says that you may not have sewer services if you are outside of an incorporated city or an acknowledged unincorporated community. And if I understand correctly, should this petition be approved, should it go to the voters, and should that be approved by voters, that then the unincorporated community will no longer exist, and it is the city. If the Capes or Terrace or anybody who has said we don't want to be part of this, if they are left out of it, they lose their unincorporated community status. And therefore, even though we have sewer available in the area, anyone who has not yet developed their lot will not be able to connect because of goal 14. Is that accurate?
That is correct, and I confirmed that with BOCC, the Department of Land Conservation and Development, during our previous hearing proceedings. We felt that was a prudent discussion, especially because of the Capes and the concerns and opposition of wanting to be included. But that is correct, and that is the information that I confirmed through DLCD.
Okay, and do you have, how many undeveloped lots exist in what is currently the defined boundary as it is stated by the petitioners?
Of Capes, it's my understanding there's roughly 30.
So roughly 30 lots.
Right, and to clarify, lots already on sewer
They
would
get to keep
remain
it.
on sewer.
Right.
Correct, but undeveloped, this is really about undeveloped lots. This is not about the developed lots.
Right, so those who have it, but anyone who has an undeveloped lot would have to do it with septic.
That is correct. Or apply for a goal exception for the Capes to goal 14 to allow sewer to remain, to be provided to those undeveloped lots. As we discussed previously, that conversation, as well as the idea of allowing the Capes to annex into the unincorporated community of Netards, right? So that was the other potential solution, so that they retain their eligibility, the undeveloped lots retain their eligibility under goal 14. The concern at the time was, even though DLCD was supportive of that annexation, the department was supportive of that annexation, it is a legislative process that is still subject to public hearings, etc. And until you go through it, there's no guarantee that it would happen. And so the concern was, if the incorporation is successful through voting, if the Capes aren't included, what happens to the Capes in relation to sewer eligibility for those undeveloped lots?
And so that comes to the question of benefits. Would someone lose a benefit as it relates to this particular statute that we're working our way through,
Correct.
right, as not a well-used statute, but benefit is the piece there, and that's why the boundary lays with us and the benefit conversation lays with us, because we need to be very careful.
Right, because without the Capes included in this process, there is no guarantee they will be able to keep that benefit.
And that would be true for other communities that also express their desire to be removed from the petition in the previous process.
Correct.
So it's really, at this point, you're in or you're out, and sewer, at least as things currently stand, lives with whether you're in or you're out if the incorporation is successful.
Correct. And it's also not uncommon to see a sewer line run right down properties that are not eligible to serve properties that are. So this notion that if the sewer infrastructure is there, they should be able to connect, that is not an accurate assumption. It gets back to eligibility under Goal 14.
Thank you. I appreciate making sure I'm clear. Deja vu all over again.
Okay,
Nothing at this time.
okay, perfect. So do we move to petitioners now? Perfect.
Mr. Chairman,
Again.
Commissioners, appreciate the chance to be here again. Deja vu comes to mind with limits. I'm here with Blake Marvis and Sharon Brown, the other two co-lead petitioners in the matter. I built a home in Oceanside 32 years ago, and I'm a puppy compared to them. They're both second-generation Oceansiders. We're all retired attorneys, so one of us still working.
That's okay. Water retire, right, yes.
And we appreciate this chance to basically come around to you on this and move forward. A couple of preliminary comments for context or perspective. You know, we started out on this whole thing, and it's daunting, and you just face this wall of issues, and then you just start pecking at them one by one, and at some point they kind of mesh into something that seems workable. And if it hadn't done that, we wouldn't be here. I think that we're coming to you with a very thoroughly thought out plan. If you review the plans that were approved in La Pine, you'll find that we probably conducted 3 or 4 times the amount of research and provided at least that much more detail going forward than was approved in La Pine, because we wanted to get this right. It's important, and we know you take your job seriously to have a comfort level on it. So a couple of important things that I think help calm the waters a little bit. First of all, at least in La Pine, I mean, especially with regard to land use, there's no cliff. The incorporated community doesn't pop like a bubble the day that the city election passes. That's not what happens. What happens is this incorporated city now has the legal status to begin building its operations and implementing ordinances that will take the place of existing ordinances. But existing operations and ordinances, either by law or by IGA, continue until the city council puts itself together, gets what it thinks are the needed resources, puts the ordinances together, it takes the training. It took La Pine 2 or 3 years to get organized and 4 years to do their comprehensive plan. During all of that time, Deschutes County wraps them like a blanket and kept things going, and then ceding to them what they were ready to take on as they took it. So there's no cliff. At least not the way they did in La Pine, and that has been the way we've approached this. It's the understanding that when we talk with county staff, we have had every inclination that, as far as we can see, to engage in that kind of a collaborative effort. That's what we envision. So there's no cliff. Secondly, it's not as big as endeavor. I'm reading some of the comments, I'm hearing other things. Wow, go to the city, how are we going to do that? Are we up to this? There's so much to consider. Unlike any other incorporation effort that has ever been done, there's only been 2 here, but there have been other kinds of incorporation before the current statute, we are simply proposing a city to fill in a gap in services that are already provided locally by special districts and would continue to do so. And to the extent that people think, oh, but the city's different and that's hard and there's so much more to consider, we respectfully have to push back. Oceanside and Etox are served by a sewer district with a $7 million budget and an administrator and a staff of 4, I think, and a trainee. And they cope with the federal and state land use laws and pollution statutes and federal grant requirements and public notice requirements and public budgeting requirements. They do it with 5 locally elected directors of a board and a skilled administrator. We have a fire district, $1.4 million budget every year, same setup, 5 locally appointed directors with the aid of the chief administering it, and doing quite a fine job. Same thing for the water district. $750,000 budget, 3 employees, it's a different title of administrator, but they manage it. Oceanside is up to doing this kind of thing. Compare what we're proposing. Basically a special district that besides ordinary city clerical and administrative functions is only going to do land use, roads, and some visitor management. Those are the 3 key things that we're proposing with an operating budget after 3 years of about $500,000 plus a couple $100,000 a year they'll have to go into a TLT reserve for tourism facilities. So what we're proposing is not this gigantic, unprecedented effort for a community of our size. We're the same population, just a little bit less than Manzanita, and they do fine. So this is not this jump off the cliff into a bunch of cold water. We're not going to be in over our head. As near as we can tell, after really exploring it conscientiously, because our heads are going to be on a block if we didn't look at it thoroughly, we do feel we're up to this, and it's not just our feeling, it's demonstrated by the other things that Oceanside is capable of doing. With specific regard to the city, we've said this before, Oceanside has a reservoir of skill and talent unlike any other community in the county. It's a bunch of retired professionals, time on their hands. And whenever we call out, I asked for somebody to survey the grants that would be available to the city. And one of our retired folks did nothing but public grants for 25, 30 years. She went out, did the internet search, got all of them, put them together in a memo for us. We cited some of them in our proposal. We have the skilled people on tap, don't have to have a paid staff. We've got people willing in an area that they love to contribute this kind of knowledge and effort and expertise. Again, no cliff, no cold water, and we're not in overheads. So, with that said, I'd like to refer you to, in the record, we offered a hearing presentation packet. We've also provided you each with a folder of it. It includes an outline, our intended outline of presentation just for kind of staying on track. But really, for our purposes, if you would not mind looking at page 2 of the folder, we've provided this, what we're calling the outline of the statutory elements. Based on the discussion of the first hearings and this one, we've put together these basically factual, procedural elements that really we think represent the checklist of the things we need to cover and you need to be able to make findings on. And let me say this. Counsel for the Capes has hinted that perhaps we're relying on what lawyers call res judicata, law of the case, collateral estoppel. It's a bunch of mumbo jumbo. What it means is that because you decided something in a prior order, you're bound to make the same decision in this next proceeding because it involves the same facts and the same issues. And you can't change your mind. You're legally bound to follow it. I'll let county counsel test me on that, but that's basically, I think, an accurate lay summary of that issue that's been introduced. And we would be quick to say, and we had these discussions with staff and county council beforehand, you are not bound to keep the same result on the findings that were adopted in the prior order. We acknowledge that. However, we have put everything that caused you to come to those conclusions in the first order in the record here. And our approach is going to be that unless this order presents some important or significant new or different information, we're not going to focus hard on the issues that really were not challenged or contested or unclear in the first proceeding. And that's not a legal maneuver, that's a practical maneuver so that we can go through the things that were unclear last time with the time that's allowed. That does not mean that your order will need to address all of these elements, whether we kind of thought so or not. You've got to address them again in this order. We acknowledge that. This is a practical approach. We're approaching things we think and perceive were not challenged or at issue or were decided last time. We're not going to waste your time and go over all the evidence and stuff again unless you ask us about specific things that you'd like us to spend time on. So that's our approach here. We color-coded this to try to basically, in the last proceeding and in the order we talked about wanting to use what we learned and the things that were decided or perceived or thought settled last time as a roadmap for the presentations here, kind of guide us. And in this outline of statutory elements, we offered 3 key elements: the petition process, hearing issues for the hearing, and the order. Those are the 3 basic components of what's going on here. And with regard to the petition process, filing, signatures, and notice of hearing, you'll see those are in white. That signifies to us that we feel those things have either were established last time or have already been established, at least through staff recommendations and staff findings in this one. So we're not going to spend time on filing or notice of hearing issues unless you ask us to and have questions about it. We don't think there's a serious challenge to any of those things. Notwithstanding, the exception, of course, would be the motion to dismiss. We decided counsel on that. That's definitely an important issue. Boundary adjustments then are the next one, the benefits issue. We have asked in our presentation that you actually bifurcate these proceedings and take your evidence and public comment on the boundary issue and make not a final decision, but a preliminary decision on that so that we all know what we're dealing with going forward, especially like budget. But we understand from county council and Sarah that might raise some serious questions about whether or not you comply with the quasi-judicial procedures that are specified for these. We think that there's, this whole thing is like jamming a square peg into a round hole. Trying to put this incorporation petition into land use procedures, but we're willing to go with that. We are going to present on the boundary issues first, our perspective. Then we're going to ask, is there more about that you'd like to ask us? If not, we'll move on. But just to kind of keep the proceedings from, oh, by the way, I still got this other question about boundaries after you kind of moved on and on. That's perfectly fine, but we're trying to make it possible to avoid that, to make it convenient to avoid that. Okay, and you'll see that we have, under boundary adjustments, we've listed 2 issues in yellow. That means we think those are live hearing issues for this hearing. Those are things we're going to concentrate on, those are things that you have to concentrate on and make decisions that really didn't get reached or completed all the way in the last proceeding. In terms of land use, staff has recommended in the first proceeding and this proceeding, based on the evidence that we presented and the analysis and proposed findings that we presented in the first hearing and incorporated into this record, that Oceanside, if any community is ready, willing, and able to step up to the plate and put together a land use plan that complies with all of the necessary goals and procedures. We put together, unlike any other community, we put together 3 different community plans over the years. We started with the first one in the 1990s, modified it in the 80s, 90s, and we did it again in 2017. So we know the path. We know the issues. We've got folks that have been through this before. We have people that are vitally interested in participating in land use issues and being educated and taking the seminars. I think staff has recognized that not only from our information, but through experience with us. We have been as active as any community on those issues in getting a hold of our ordinances and asking for changes and trying to customize them. So we're not going to consider those issues that we need to touch on more than briefly at the time that we come to them. And then in terms of economic feasibility, we are under the impression that our tax calculations, with the corrections that we made with, actually tax calculations have been absolutely verified by Denise Sandicover, and I gave her a point-by-point step of how I was calculating and projecting the tax revenue. She wrote me back and I said, there's a couple of rounding things here, and she goes, those rounding things are minimal, this logic makes sense. I agree with your tax analysis. So revenues on city tax calculations are good. We also, in order, included and agreed to that our information that we use to put together estimates of the cost of services, other revenue besides the tax, other revenue that's out there, and then all the services costs, basically our resources and our requirements elements of our budget, to basically agree that we did due diligence, that we went to the places that you should go to ask for this information, and we applied that information in our analysis. So except for when you ask us specific questions about that, we're not going to go through a point-by-point analysis on those things. Some things we figure you will be interested in and we'll be ready to do that, but we're not going to shoot with a shotgun and just hit that one bullet shot on those. So we're not going to spend a lot of time on our methodology or our sources of information, except that they're reflected in the record, in the written record, and we'll be glad to talk about them orally. But in yellow then, these were the key issues that were identified in the last order, on which more effort was needed to provide enough information for you to make a decision in the affirmative. These included, first of all, the adequacy of the tax rate, which we've broken down into the amount raised, comparison data, and the accommodation of growth. Those seem to be the key factors and questions in the commissioners' minds, and so we tried to focus hard on responding to those, and we will do that when we make our presentation. Roads program, same thing. We really focused on it. We reviewed the tapes of the prior hearing, wrote down every question you had, and tried to answer that mainly through the vehicle of input from Chris Leahy, who is currently doing all the things that we're proposing to do. And then finally, there was an issue, some concern about reliance on short-term rental income for the proposed city, and we will address those things. And then the third issue is just basically findings and order, and that's going to basically be a Scrivener thing, maybe a little bit of negotiation and input at the end, how to draft an order that expresses your decision. So that's our proposal for going through the statutory elements and how we're going to approach them, and in the order we're going to approach them. Just for the sake of completeness, we did also include in these materials the actual order from last time. Anybody wants to check what was said or how it was worded. Just going to, I have included a piece on page 9 just to make it easy to refer to the timeline of our compliance, our final petition, our getting signatures, I have them verified, our turning in, and our scheduling and notice of the hearing. And then, thank you for this, prompting this, but we had a great gathering at my home where we had 10 people sitting around a big table with postcards and stamps and mailing labels we printed off the tax base provided by the county, and we spent a day putting together 950 postcards and sending them out to the community. We did that on the same day that we turned in our signatures. We felt like that was the point where things had ripened enough that we wanted to let everybody go, hey, this is happening. We mailed them out, and that was we think a response to a suggestion the commissioners made that helps add a comfort level to what wasn't required by the statute. We think it does add to the quality of our notice process and the public input. And then I just quoted staff report to the effect that we have complied with our those requirements, filing requirements. Those may be verified further by staff, but we're not going to spend more time on it. So, are there any questions about our preliminary explanation of our intent, our proposal to go forward? Things we've discussed so far. I said we want to try to avoid we want to try to proceed in mostly a straight line from beginning to end. So, because last time we feel like we probably let ourselves go back and forth a little bit, and that led to a less efficient, maybe even a less helpful presentation. So we're trying to be very intentional about this now. We give you every opportunity, if you think of them now, to ask questions about what we presented. So the next issue is the map issue, the boundary issue. We've been very plain that this is a hot potato that we feel we got our fingers burned on, and we've decided to hand back to you. Obviously, the range is going to be the case, but we have gone ahead and prepared some input for you. Our perspective, to the extent we think we can help you with this decision, it's really your decision, but I'm going to go ahead now and turn things over to Blake, who's going to take the lead on this part of the presentation.
Hello again, Commissioners. Glad to be back here with you. Looking forward to round 2 of this. Thanks for your time. As Jerry mentioned, I'm going to be jumping into the benefits analysis, and essentially follow along. Petitioner's hearing packet is going to start on page 11. This is the section we're going to walk through here. So just as a brief overview, the statutory section that applies and actually gives you discretion to determine whether boundaries can be altered for this type of petition comes from ORS 0400, subsection 2. Wow, that one.
Easy to zero.
Yeah, zero. Essentially, this establishes that the board can determine whether any areas that are benefited by the proposed city should be included within the city boundary area, and if there are areas that are included in the city boundary area that will not benefit from the city, then those can be excluded. It's important to remember, as you probably remember, that this section allows you to alter boundaries, but it's actually not a statutory basis to deny the petition. And so really what we're looking at here, whether there should be changes that can be made for the boundary of the city in terms of excluding or including certain areas. This is some reason why, as just a practical matter, it makes sense to determine that to some extent prior to moving on to other issues, because then we can have a clear sense of what the proposed city boundary will be, whether tax revenue will be coming from certain areas that you may feel need to be excluded or included, and other issues like that. Either way, though, as I'm sure you'll see in our economic feasibility analysis, whether any of these areas are excluded or included, they're asking to be excluded, they won't substantially affect the tax revenue to a point where it would make the city itself not economically feasible in our minds. So the benefits meeting, unfortunately, is not statutorily defined, so we kind of have to look at the plain meaning here, which I think in the county's position and staff reports, we've looked at essentially kind of key areas that determine whether benefits are granted to an area. In our minds, these include strategic use of TLT revenue. This also includes the benefit and access to 30% of TLT revenue funds that will be used for general use. Stronger regulatory administration of short-term rentals is another benefit that we believe is present. Greater degree of control over land use review and over regulatory administration. Specific city code enforcement programs that will be implemented, as well as emergency preparedness coordination for the city boundary. And so these are, in our mind, kind of benefits that we can actually look at. They're tangible, they're objective, and we can make a determination as to whether they correlate to each specific area. The broad theme here, I think, is really that it's about more local control for the city itself and for individuals within that area. Now, the areas that are specifically have requested to be excluded include the Radar Road area. And if you look, actually on page 14 of the map, or page 13, sorry about that. So the Radar Road area, the Terracea area, the Capes, and Avalon East and West. And so we have essentially 4 core areas that, in our minds, have requested to be excluded from the petition, arguing that they won't be benefited. And so what we provided on page 13 is a chart that essentially goes, page 14, sorry. It's a chart that essentially goes through and identifies whether we believe these core areas benefits are provided to each area that's asking to be excluded. And so I'll just go through these briefly. The first one, land use services. Essentially, we think all areas will have some benefit from this certain city service, with the Capes having a potentially limited benefit, yet a benefit nonetheless. And so really what we're looking at here in terms of land use services is, one, whether there's access to a mechanism to address complaints, to address other code violations, and similar types of zoning violations specifically. So having access through the city to file a complaint about a zoning issue, that's going to be a benefit that people in the area will have access to broadly, that we think would be included in each specific area. Even though the case is regulated under kind of the homeowners association, has other specific requirements, these are still going to be these are still going to be mechanisms that they're going to have access to as people who are part of the Oceanside city. And then, as has been discussed pretty extensively, the sewer eligibility as it relates to land use goal 14. That's a pretty clear benefit in our mind. We don't have any reason to really dispute the county's analysis on how that would apply and how that would function. So with that going forward, we think that presents a benefit that's tangible, objective, and applies to each of the areas. The next one is road maintenance. And essentially on this one, the key consideration here in our minds was whether there were county access roads within a particular area that could be benefited by the city taking control of its own roads program. And so in the areas that we've kind of separated out in Oceanside, the different neighborhoods, the different districts, what we see is that the central village area has local access roads. they would be benefited by having those roads being maintained and improved by the city, where the county currently doesn't provide any of those services. Avalon East and Avalon West, as a person who lives off one of those county access roads in that area, they desperately need attention, and so I think that's a clear benefit to the area. But purely on a less individualized level, just the existence of those county access roads within the area provides a benefit because we will now be getting continued maintenance. Radar Road is similar. Radar Road itself is a county access road. For the Tercey and Capes neighborhoods, those two, since their road maintenance is done through their HOAs, probably not a benefit there for them in that specific category.
Those are private roads.
Yeah, private roads.
Those are private roads.
Looking at code enforcement, this is pretty simple. Access to a complaint process for a variety of issues. That's going to be something that covers each area. The Capes perhaps somewhat more limited because of the homeowners association and the viability of having that enforcement mechanism. But otherwise, this is a benefit that we think applies to each boundary location. The city amenities, I think this one is something that is going to benefit each area as well. When we look at city funding projects that we're going to be able to do through TLT revenue, through general budget, it's not as though any of these communities that are asking to be restricted never have people who travel down into the central village, never have people who travel to beach access, never have people who use various city amenities. And so having funding for those type of services, having improved continued development of potentially new parks, potentially new walking trails, continued maintenance of beach access, all those sorts of things are going to be a benefit that's objective to everyone within the Oceanside growth boundary. And so we think those apply pretty broadly across the board. As just one note, I think Oceanside has strong past history of communities, including all of these districts, coming together and contributing to projects. For example, we know that people in the Avalon area contributed to the beach access that was recently put in. The same is true of the Capes. The same is true of people from Tercey. So all these communities will get a tangible benefit from those types of projects. We already work collaboratively with those communities as Oceansiders, and we consider them part of the city and part of that process. So I think that when we look at how actions have been taken in the past from people and from organizations within all of these boundaries areas, you can see that they certainly envision that they're benefiting from these sorts of services because they're providing funding for them. So I think that shows that that's a benefit that clearly affects everyone. Everyone's involved in contributing to it now, where the city would simply take over those types of projects. And then the last one is emergency preparedness. Essentially, every district would benefit from this. We'd have more access to grant, we'd have more access to funding generally to prepare and to have kind of more materials, supplies, planning projects. These types of things would be enhanced in terms of the city's ability to navigate those issues. And as well, what we've seen in the past is that the Capes, other communities that are asking to be excluded, they've all collaborated on emergency preparedness information. They've worked with other districts in Oceanside. And so even if something like the Capes, who has their own kind of emergency preparedness aspect of their HOA, they're still going to benefit from a collaborative approach with the city and supplemental emergency preparedness that the city will be able to provide on top of any services that are already provided. So I think regardless of whether specific communities have their own individualized emergency preparedness plans that make sense for their area, the Oceanside city as a whole and the city's ability to develop those programs will be something that benefits each of the communities asking to be excluded. Just kind of a final note on this analysis and the benefits before opening up to any questions you may have. Really, I think it's important to remember here, based on some of the comments in the record, that this isn't a subjective, individualized determination of benefits and of whether someone should be excluded or included in the city boundary. We're not looking at specific properties, we're not looking at specific people or whether they believe that the city would benefit them personally. Rather, this is an objective analysis as much as it can be in terms of whether these areas are going to have access to city services that will provide theoretical benefits to them. And so I think that's important to keep in mind, that individualized, subjective determinations of benefit, that's really for a vote if this is approved by you, where we your analysis here is about objective beneficial findings within areas, not subjective determinations. So that makes sense, just as a final point of clarification. But obviously, any questions, this is a pretty important issue, so I'm assuming you're aware of this.
If I would just supplement just one aspect of it, because it would be the 800-pound gorilla in the room. At the first hearing, we took a position that we thought it was pretty clear the case would not benefit. And now we are offering the case for how it might. The sewer issue was from both years, so that's, we hadn't considered any of that in taking our positions in the first hearings. But as the case has noted, this is a brand new proceeding, looking at all these things fresh, even though the evidence might be the same, the conclusions might end up being the same. But we think we have an obligation to indicate that we still appreciate and sympathize with many of the arguments that the Capes will present for being excluded. They still resonate in many ways with us, but since we went ahead and essentially took the commissioner's suggestion to go ahead and add them back in, we felt an obligation to at least make the case and offer the arguments for how they could benefit. But we still recognize that this hot potato is in your pocket, not ours. But as the petitioners, and we did include them, we thought we should at least present the arguments for why they would be benefited. Being frank, we still think they may be much closer call than any of the other areas. So we just want to be transparent about that.
Questions for petitioners?
I don't have questions at this time. I appreciate the chart and the effort to look at it objectively and list out benefits and compare. So I appreciate that work. We were missing that previously, and this is a good clarity.
Yeah, I agree.
So I just have a couple of questions here. You mentioned that short-term rentals with stronger regulations. That brings to mind enforcement. That's a problem we have at the county level is enforcement. Do you have a plan moving forward on how you would enforce any increased regulation of short-term rentals?
We're actually going to include a presentation on that with our discussion of reliance on short-term rental revenue.
Okay.
If you don't mind, just to keep this fun. We did anticipate that in the response.
So again, let's just do a what if here. If this continues to move forward, if indeed you incorporate, if indeed the case is included, they're not a special district. They are the Capes itself. That is a development. They have their own.
Their subdivision.
Okay, they have their own, some of their own land use regulations as far as short-term rental regulations, not allowing short-term rentals, things of that nature. If they are indeed included in a positive vote from Oceanside, would their own regulations within the Capes go away and they would have to fall under the City of Oceanside regulations, or would they be able to keep some of their own regulations, as it were?
Chair, you're looking at me, so.
Well, I don't know. I don't know. Let's go. I'm sorry. Let's go back to the. Okay.
We anticipate respecting the contractual obligations that people already have about control and use of the land. At this point, we don't understand that any of them conflict with applicable county zoning and use standards, and the only conflict might be if the county somehow, or a new city, tries to implement new regulations that were more restrictive than the contractual one. That is a hypothetical question for city council in the future, but it's not my experience that cities that would do things that are more restrictive. Usually the reason for having CC&Rs is that people want to be bound to do things that the city would otherwise let them do, or the county would otherwise let them do. So our assumption, to the extent, we have to just project here, we're not the city council, but our assumptions and projections are that the city would continue to respect those, unless there was some kind of gigantic, fully vetted discussion of some rule citywide that got voted in, but somehow would conflict in a more constrictive way. I can't envision what that would be.
So Jerry, you opened the door for me by mentioning city council. Has there been thought on how your city council makeup would occur? Would they be by districts within the boundaries of the city of Oceanside? So that if indeed the Capes were included, the Capes would have a representative on the city council, Avalon, things of that nature. Have you thought about that at all?
Well, I can definitely say I thought about it, but the better answer is, first of all, I had a bunch of those questions and contacted the lawyer that helped Lapine set things up and eventually get to his charter. The way the law works is that the statutes actually include a ready-made makeup for the city that takes effect unless and until the city then works on and adopts a charter that says something different. So the way it works is that the statute requires in the same election that the incorporation election is in, there is a time frame before that for people who are interested in being on the city council, if it passes, to file for election. And the top 5 people, and that vote takes place at the same time as the incorporation vote. And if the incorporation vote is yes, then the top 5 vote getters become the city council. They choose a mayor, and they go forward under the ready-made provisions in the statute, kind of a bare bones charter, if you will, that is already put in place for how the city can rely on it to operate, even though it doesn't have a charter yet. But then they have the power now to have public hearings and have public input on how they want to organize for the future, and can then, through hearings, put together a charter that might say divisions, sectors, however you want to do it, how many people on the council, strong mayor, weak mayor, mayor, strong manager, city council managed, all of those things that are going to be within the options of the city to do, but meanwhile there's a safety net in the statutes with some bare bones ways to operate in the meantime.
So the initial city council would basically be set by the incorporation vote.
Yes. And also it establishes by terms based on who comes in first, who comes in second, who comes in third, just 2 and 3 year staggered terms.
Yeah, just for clarification, would be, do you want vote on incorporation, yes or no, and then individuals run interviews as
Yeah.
well? Yeah.
2 different things on the ballot.
Right. And so let me get this clear. So the people that will be on the ballot running for city council, they are going to put their names in a hat, or going to be chosen at random, or how does that work?
No, they step up to the plate.
Okay.
Anybody that wants to run for city council
Okay.
has to follow the rules. There's a window for doing so.
Okay.
The county clerk on the procedures.
Okay.
There is no voters pamphlet. City elections aren't allowed in state voters pamphlets. Unlike some counties like Deschutes County, they put together their own county voters pamphlet. We anticipate there's going to be some information paid for and disseminated. Now, our group certainly plans to, but just to be clear, it's all part of the campaign. It's not part of the official voters pamphlet. We didn't write the statute.
I understand. I see some potential problems there. I do. If and when we get to that point, I would ask very strongly that you recommend doing what you did at the request of this commission previously. Send out a mailing to all lots in the new incorporated city, should that occur, just to make sure everyone understands. I see some potential pitfalls moving forward if we get to that point. I do.
I can't commit on that at that time. I think our plan is to focus on the people who are voting.
I understand.
And we anticipate that because those people have been alerted to the extent they want to get involved in the campaign and raise money and do things, they're going to have that power just like anybody else. Petitioners don't feel like we're obligated to fund.
I understand. It's just that, to me, transparency in this issue is going to be extremely
Oh,
important.
I draw. There will be visibility. The town will be afire.
Thank you. Any other questions?
It's time.
Okay, where are we going next, Eric?
Okay.
Oh, the petitioners are going to continue. Okay.
Land use is next. And I'm just going to touch on it because I already touched on it briefly. We included in our first petitioner's analysis and proposed findings a goal by goal explanation of how we would establish that we are willing and able to put together a comprehensive plan that does comply with them. our current comprehensive, our current community plan does, and the county, in order to have their comprehensive plan acknowledged that included our boundary, they also had to go through the analysis of that everything that's currently set up is in compliance with or comports with the land use goals. In our order, we proposed that we adopt our findings on that and our proposed analysis, so you have to repeat it in your order. And that was a move that was endorsed by Director Absher. And so we're just basically asking for all of that to be done here again, absent new interest or different interests on your part to reopen it in some way. It's all there. That's why we ask that people record be included in this record. If you need help finding it, we'll get it covered out to you. I'm sure Sarah knows where it is. But we put a lot of work into that. Interestingly, that is not an obligation in the statute. That is an obligation that was tacked on by the Oregon Supreme Court in a case called 1,000 Friends versus Wasco County, Rajneesh Param. Some of us are old enough to remember that, Policy's fun endeavor. And that case decided that because even though approving a petition doesn't involve making a land use decision, it's going to lead to a land use decision if incorporation passes. So the court recognized that even though there's no real land use decisions being made now, there has to be some indication in the record that when they are made, the city's capable and willing to comply with them. So that is the nature of our presentation. You don't have to go through a whole lot of analysis in order to have complied with them. There's no acknowledgement process. It's just a confirmation process based on our history and staff input and the record that we can do that when we need to. And I think that's really all we have on that. We would just ask that you go ahead and adopt those findings again, and Director Archer has repeated her recommendations that are staff findings in that regard. So moving on then to economic feasibility, kind of the big nut to crack here. We've divided this up into the areas that seems to be of most interest to the commissioners, or of most concern at least, and we've broken up how we're going to present them. As an overall matter, we would remind you that our broad information on revenue and resources and requirements have essentially been, remember, this is not an accounting exercise. This is a feasibility exercise. In theory, with this much money can be put together a functioning city that provides the services this city is proposing to provide. We have to offer a hypothetical budget, one way to do it. It isn't a fly spec situation unless some figure we use is so out of line that it disrupts your ability to find that this is a feasible project. But you're not endorsing the specific budget allocations. The city council is not bound to these allocations. This is a way we have put together one possible way to put it together in a feasible way and to establish that it can be done. How it will be done is going to be up to the city council. But given that this is such a rare situation, and we're unaware of anybody at the county that's run a city, we went out to Dave McCall, and we bugged him. And we went to him one of the very first people early on because of his breadth of experience and what we think is a solid credibility on these issues. And Bay City's going to do a lot of things in the way that we're planning to do. They've got a brand new city manager. They've been through the mill on converting from strong manager, from strong city council to more stronger. He knows the spectrum, he knows the pros and cons. So we just asked him to write a letter, look at our situation. He went through it in detail. He offered us some really good advice on it, some things to be careful of, some things to approach first. But for the purpose of this, he blessed it. For what that's worth to you, as a current mayor with a lot of experience in dealing with how to put together a functioning city, he's looked at our proposal and he's characterized it as reasonable and rational. That's the bar we have to meet, we think. So to the extent we need something in the record from someone who I think would be an expert on that, we went ahead and got it for you. So that's there. So I think that's all the preliminary comment on that. As in addition to the ones I said earlier, like this isn't a cliff. This is something that we think we can do. We have really grilled a lot of people throughout in the state on these things. And so our application of this tax rate to our proposals is not just a wish list, and it's not just from our gut. It's a conclusion we've reached based on a lot of analysis and research and outreach. So with that, I'm going to turn it over to Sharon, who's going to discuss the issue of the adequacy of our tax rate. We think that there were some perspectives and some information that did not get fleshed out adequately to give you a full picture of how to make that decision the first time around, so we've gone out and tried to fill those gaps. Sharon?
Hi, Commissioners. I'm Sharon Brown. I participated in the attempted to participate in the prior hearing through Teams and was unable to make the sound function work. That was very memorable in my mind, and you also may remember that. In any event, I'm really happy to be here today to discuss this with you. Blake and Jerry mentioned we have some history in the area. My grandparents lived in Oceanside. My father continues to live there, and he's 90 now. Vernon Dick served on virtually all of the districts that had a board of directors, sewer, fire, water, etc., over his many years, and created a template for how you act as a responsible citizen that I'm trying to live up to. So, part of the reason I'm here. The tax rate issue is something I was strangely excited to talk to you about, because I do think it's one of the most misunderstood and perhaps a little hard to translate why and how these figures work. But we, after lots of time and lots of people, lots of volunteer effort within our community, have come to the conclusion that it fits us. And we're unique, we're different in some ways, and yet similar to many of the other small cities in the county, but our special districts really do make it a unique mathematical computation. So I'll try to walk you through that at this point. I also, I'm very cognizant of the questions you had at the last hearing, as well as the many comments that were made through the record previously. And I went back through all of them just to refresh my memory, and I'll try to cover the points that were raised and the concerns that people had that caused us to really look hard at these numbers, and we still believe they are valid. We also have built into this process, just as a note, if you exclude an area, it will not substantively affect our numbers, and we can go through exactly how that works with you, but we have made sure that our basic numbers, our basic income and basic expenses are going to be valid no matter how that plays out. When you make a decision on the boundary, that will help us focus it so we can be very specific with you, but we're comfortable that these numbers will stand. So, Jerry will address the short-term revenue in more depth in a few minutes, and then Blake is also going to discuss the roads and how they impact the budget in a few minutes, but I'm going to talk about the tax rate generally. You have a chart in your materials on page 20 that really talks about our base rate and how it compares to the other cities in the area. That is interesting to look at. It also is worth noting that these other cities also have their own unique mix of whether they provide fire or sewer or water or so on. So we have tried, and we did make contacts with and reviewed the budget information for all the other cities in the county and outside the county that have similar issues, coastal cities and so on. And our our chart rather includes Yahop's here as well, just to give you kind of a picture of how they look at things differently. The things that really make Oceanside work with a relatively low 8% tax rate causes you, it is based on our valuation of the properties and our kind of stable population. You'll note our chart gives you the assessed values of the properties within our proposed boundary, what that tax rate would cause you to get in terms of a proposed actual tax revenue from that, our population, and then our revenue per capita, so that's dividing the revenue by the number of people in the city. And you can see that relative to the other cities, we are positioned very well and very comparative to them in those numbers. We come out as the 6th highest in this list of 8 in terms of the tax rate. So it's a relatively low rate. We are 3rd, however, in assessed value, so that multiplies it, boosts that number up, the actual revenue. We are also 3rd in property tax revenue, which makes sense because you're 3rd in the assessed value. But we are 1st in the per capita tax. So actually that means the money that the city would be spending on the city inhabitants and the properties within the city is actually very well positioned in comparison to other cities. And then finally, our TLT revenue, which, as we noted in the materials, appears to be understated by quite a bit. The more recent numbers we've received, especially in our meeting on Friday with Sarah and Sean, treasurer and land use director, show that may be even double what we've put in our budget. We know that that is money that is hard to predict, but I can't see, based on the figures for this year, how it's going to go down. And that's one of the things that Jerry will discuss in more detail. So we did a lot of research and looked at exactly the services that the city of Oceanside would provide. And actually contacted other cities and asked them specifically, how do they spend money on administration, just generally having a city run, the land use decisions that we'd have to make, the other services that we would be providing hopefully in the future. It's interesting, and it's been, because of the way the timing and the statutes are now set up, our first year and into the 2nd year are going to be quite spare because the tax income won't start coming in. But the tax rate is one of more than one sources of income for the city. The TLT and STR income certainly is another one. There are also grants. There's revenue sharing. There are many grants that are available only to cities that are not available to the Oceanside community as an unincorporated area. And the other cities, as well as the LCDC, which Sarah always tells me what those letters stand for.
Land Conservation Development Commission.
Yes. Thank you. But
I sued them before, so.
And we met with them. We met with their local representatives as well and talked through these numbers and went through how is this reasonable? What are the things that we would spend that money on? And everyone has been supportive, cautionary as well, told us where to look for more information, what potential pitfalls might be, and we've tried to work those all into our presentation. And the fact that we're having a first year, spare year, does not mean this is not feasible, I guess is the point I'm trying to make. And I know that's a double negative, and I thought really hard about whether I wanted to say it that way, but it's the most accurate way I can present it. The fact that we have a spare year does not mean that it's not feasible. And the significant efforts in our community by volunteers that Jerry referenced earlier really is something that will help carry us through. And we have a history of it, not to say that other communities don't in the county, but Oceanside has been traditionally very involved in community matters. And members have been incredibly generous in sharing their time and their talents. We don't believe there's any reason that that's going to not continue. I would also say that, we also have I'd like to thank personally all the people that sent comments in, negative and positive, because they gave us the information, because people have concerns and their concerns are valid. And we need to be able to look at those concerns and explain why we believe we have a plan that's going to work with those. Politics is, I heard someone say once that politics are always messy. And doing something big causes people to worry and to express their concerns. And so we want to be able to include all those concerns and be able to work through them. And that's why, again, assuming you all decide that this is feasible, it then goes on the ballot, and then we get to go through this process where people get to say yes or no with their ultimate vote, which I think is the best way that our politics work, with diplomatic and polite discussion. Maybe not always polite, but we try to make it that way. That's my personal desire. So I would like to thank everybody who's made comments, pro and negative, because I think it's a very important part of this process and to us. So with that, our page 20 in the packet is our chart, and then following that is our growth information. There is a page 21 where we specifically tried to address some of the concerns about growth. Oceanside has had a very stable population with a lot of people who are part-time residents. That's one of the beauties about our neighborhood association, because if you live or work in Oceanside, or if you own property there, or if you reside there part of the time or full-time or whatever, it's inclusive. So that, and I didn't mention this, but it is kind of important. I'm the incoming president-elect for that position, so I have an investment in that process as well.
Congratulations.
Thank you. But we did try to address in this chart on growth that, for example, between the 2010 and 2020 census, we only grew in population 0.02%. On the other hand, we have significant development that continues to go on, and there are a couple of mentions in there. Avalon Heights is one. There's a big new development there. The plan is, we understand from that developer, to build that out within a year, which would be incredible. I don't know if that's, I think that's a very
I
optimistic.
jump in on that a little bit. Within a year, he's going to build out 5 to 8 units. He plans to complete it within a decade.
Go within a decade.
Okay.
Yeah.
You're right. Maybe I overestimated.
But significant new, adds 10% to our building lots, and to our, that 10% of the number of lots in our tax base. And each one is going to be worth, apparently, according to the appraiser, $175,000 before we build on it.
And then additionally, the hotels that have been discussed previously, that we understand in the planning process for those also will benefit financially the city because of the different taxes that will come from that, as well as with the real estate development, the assessed value when those properties go from unimproved lots to homes will actually boost our income. So in many ways, growth isn't something we're afraid of. Certainly it's something that life brings to us, but it is included within our proposals, and I think dealt with in a constructive way. And then our proposed budget is included. And then
on growth, just one additional thing. Because Commissioner Scott and I here had a discussion about, how do you cope with the 3% cap on growth, when the growth can exceed that. And this circles back to the discussion of how unique our proposal is. When there's growth, usually the accompanying costs are infrastructure and schools and things that are going to continue to be provided and growth absorbed by the special districts. Growth doesn't have a particularly large impact on planning services, except staff time, which there are fees that help absorb those. So planning services are not an area where growth in the city, in the population or number of houses, is likely to outstrip our 3%. Roads, it's our understanding, our assumption that the city, just like the county, will continue to have developers put in their own roads and have those costs. So those are not costs the city's going to bear of growth, although the cities will then probably be taking on some maintenance obligations. We discussed that in our proposal. And then code enforcement. And that can grow in relation to, and perhaps higher. Population growth might bring more need for code enforcement than the budget can sustain. And that's where we circle back and look at all the other revenue projects that are going to come in that aren't subject to a 3% cap. Not counting, there's turnover in Oceanside. People just sell their houses and they're selling them, and the property value is going from $300,000 or $400,000 to $1 million. That is not even an exceptional situation. And then the values get updated, not subject to the 3% code. On top of that, everything new, there are 64 recently approved subdivision lots in Oceanside and current plans to develop them. As soon as they are sold as lots, the valuation goes up. As soon as they are developed, it goes up. All of those things we think more than adequately help us put thought into how we're going to cope with growth. Those things are going to give us income beyond the 3%, probably way enough to meet our growth plans, because so much of it is self-absorbing. And we're not anticipating gigantic commercial growth beyond the hotels, because there's no room. Our commercial area is almost full. And if we do expand the commercial area, then all the economic factors are going to be fully vetted in those. Okay, thanks.
I think that concludes my tax rate. If you have questions about the tax rate in particular.
I might always want to ask you questions.
That's okay.
So in looking at, I'm especially interested in your TLT projections. So you're projecting for Oceanside initial year probably about $315,000.
Correct.
That is the 30% of the transient lodging tax revenue coming from Oceanside that you can use for whatever you want. Is that correct?
No, that is the total gross we expect if we passed a 9% tax. Currently, the county is collecting $350,000. I mean, I'm going to amend that in a minute, but assuming that our original figure of $350,000 that the county is collecting from Oceanside short-term rentals,
Okay.
that 90% of that is $315,000. That is in our budget as a total TLT revenue. In our expenditure side, you'll see that we put 2/3 of that into the TLT reserve and only applied 30% to our operating budget.
Okay. So that takes me up to the Manzanita number. You're saying that Manzanita collects $540,000.
That includes hotels.
That includes hotels. But that is also available to the city of Manzanita 100%.
Actually, I think it's 70%. I read that their prior statute allocated it a certain way when they passed it.
Okay.
So
They're grandfathered, so they can utilize their transient lodging tax dollars any way they like. And so it's my understanding that a lot of it goes to public safety and the police department, things of that nature. So I'm hoping you've taken that into consideration when you compare yourself to Manzanita. And their transient lodging tax revenue is larger, and they get to use the entirety any way they like.
I think we raised it as a comparison in order to address the issue of whether we were relying on it too much. And we were saying Manzanita relies on it more. And if there are economic situations that cause short-term rentals to be an unstable source of revenue, we're not the most exposed city in the county.
So I'm just saying it's difficult to make that comparison with a potential city of Oceanside with the city of Manzanita.
On how we spend it.
Yes.
Yeah, just about how much we rely on it. But I now, this is a good time for me to add, and Sarah, and if Sean Blanchard is around. But when we put this together, I have emails from late into 2021 that the receipts were about $350,000, 3/4 of the way through the year, and then as I did this, I asked what was the complete number, and what are the first quarter numbers for 2022? And there was a delay because Tara's office is just crazy. But about a week and a half ago, or 2 weeks ago, I guess maybe, I got a response. So I asked them, and I said, okay, what were the 2021 TLT revenues? We were kind of using this dated number. And he said $636,000 for 2021. And I said, well, I didn't say yes, but that's what I was thinking. Because that was more along the lines of the numbers that on the website, if you look at TLT revenues reported on the website, hasn't been updated in a while, but where there's a number for Oceanside over the year, and it includes NETABs. And it includes, I didn't know that, it includes NETABs and it includes Cape Mears. So when I got the 636 number, I shot back an email and said, no, I don't want the number with all three of this, just what's Oceanside. And that's at $636,000. Now, during our conference with John Blanchard, where she pointed out that we were 25,000 short, it was a 25,000 gap in our third year budget. And this is hypothetical, this is projections. But we had plugged in only $325,000 there, just applying a little bit of inflation. So we had kept really, really conservative. But we got, Johnny, was it? Tommy, joined us on the Zoom, and I came close to and maybe even went into rude territory because I just said, I don't want to be blindsided by this. Are you sure? Say it again. Say it in front of these witnesses. $636,000, and he said, absolutely. And for the first quarter of this year, $101,000. Winter is usually only about 10 to 15% of the total. So by our projecting $315,000, $325,000 in the second and third year, we could easily have under budgeted available funding by close to double. We didn't adjust our budget for that. We kept it the same as we came in with. We were dancing with the one-quote promise. But to the extent there are doubts or concerns in those first 3 years about us not having enough resources for the things that we outlined, that's a heck of a buffer. We're not counting on it. We're not asking you to say this for sure. But as much as I could, I confirm that at least it's going to be there, even with a pause. I'll talk more about the reliance on short-term rentals there, but you asked the question about it. I want to be sure. That's why we put it in red. And this number might need to be adjusted up to almost double. Okay.
So we're going to take a quick pause here. And for the time being, 10:33 a.m., we're going to take a 5-minute break. Okay? Thank you. So, and we need to mute some people online. Thank you. I don't think that's me. I think I'm off of all my. I just lost it. Still here somewhere. So, time being, 10:43, thank you. We are going to come back into our public hearing. So we're going to Sean and Cassie next.
Chair, I believe the petitioners still have a bit to wrap up with their presentation.
Okay, so I do want to say that, I am supposed to be in Pacific City at noon today for a meeting. So I'm going to ask everyone to please be as brief as you can moving forward. We do have a lot of public testimony to take also. Don't mean to cut you short, but if there's anything we can do to speed things up, that would be greatly appreciated.
Okay, well, that's a perfect segue then. To my saying, we're kind of nervous you're not asking more questions and taking more time on the presentation. We're not really ready to trust that we're doing such a good job of answering all your questions ahead of time. And last time, a lot of questions came up after our rebuttal, and we really are trying to, and we couldn't answer. We wanted to, and we couldn't. And so, if it means stretching this into another session so that our presentation is broken up, we're not going to object to that. We kind of expected it, but we really, really hope, as part of our case, we are planning we're planning that you would have everything you need now, and we bend over backwards to get you your information. And if there's anything at all niggling at you now, let's address it now, rather than deliberations or it's a question we didn't answer, or it's a question that just occurred to you, if that's fair. So it's time versus thoroughness. We'd appreciate thoroughness, even if that means stretching us to the next session. So
staff and council, what do you think of that idea?
Of what? Of continuing the rest of your presentation, say next time? Jerry, is that what you're saying?
yeah, if you need to convene, adjourn the hearing for now or continue it because of time constraints, we're amenable to that.
Yeah.
And in fact, it might even be a good idea.
Yeah, I was thinking about you, Dave. You probably wanted your opportunity to chime in at least at some point today, right?
And I won't until you ask.
So I think that's a good idea, since both Sarah and I really need to be in PC by about noon today. And we have at least 45 minutes of public testimony, and we do want to give the petitioners from the Cape an opportunity to make their case. Can we call a pause to the petitioners' presentation and take this up again at the next meeting? Is that okay with you?
Yes.
Are you at a good stopping point in your
If we can
presentation?
find another stopping point, or?
I would say, in my opinion, what I think that Sean is going to testify about relates to our tax presentation, which we are just at the end of. So maybe you might want to, since they're so busy, let them do their stuff.
Okay.
And then that, absent further questions, which you can ask next time, we're going to move on to roads next. And so it'll be a good breaking point.
That's a good breaking point for you. We'll bring you back at the start of the next hearing. Sarah, you good with that?
Thank you, Chair. I am. I would just say that if we are continuing to add new evidence into the record, even through testimony, we need to make sure we do not close the public record on the rest until the petitioners are done and the public has had a chance to comment on everything we shared to date.
Okay. Council, would you agree with that?
Yeah, I think it's a great idea.
Okay. Okay, so at this point then, let's see if we can get Sean and Cassie. Sean Blanchard, our treasurer, Cassie, the county clerk. If you were both on, would you like to make any comments as to the tax portion of tax and income revenue portion of the presentation?
Good morning, commissioners and everyone in the room. You just froze.
Well,
We can hear you.
We can hear you fine.
Okay. No, I don't have any comments to make. I had a good conversation with Mr. Keene and Sharon and Sarah last week. We also included Tommy Cyber, who's the accounting clerk for TLT funds. Mr. Keene reiterated how he met up and confirmed, excuse me, with Denise Van Koovering, who's the county assessor, where he came up with the tax amount, confirmed with Tommy the TLT funds that they could potentially look at receiving. So I don't have any other comments aside from that. I know Mr. King received, well, I don't want to say rates, but confirmation from Director Lady with Public Works as far as what the cost would be. And that's about all I have to say at the moment, unless you have a specific question for me, commissioners.
I do, Sean, if I may. You and I had a conversation regarding just uses of particular funds, and that within their budget, they would break it out and say, this is exactly what he pays for, this is exactly what property taxes pay for, just to ensure that there was no cash flow or other issue that was going to be unexpected because of when funds come in and when bills will arrive and what can and cannot be used. Did you have that conversation with Mr. King?
We had a high level. I don't think I put the request in writing, but I can definitely send that to Mr. King and then forward to the commissioners.
And maybe they were gonna talk about that when they got into the rest of their budget. I know we're kind of in a funny space right here, but just because you and I had talked about that, Sean, I didn't know if you had done that.
I think I hadn't spoken to him until after I spoke with you, so.
I was just related to that, I had conversations early on with Denise Van de Kolen. When do these kinds of tax things generally come in during the year? And what percentage do you get in each part of the year? And have we incorporated that into our projections? So, if that's the question you're asking.
Yeah, the question is whether, here's your TLT, here's your tax amount, here's your TLT amount, here are your expenses, which is paying for which, just to ensure that you really do have the unrestricted funds that you need to pay for the things that are only allowed with unrestricted funds, and that your TLT is paying for things that are only allowed with TLT as part of the feasibility question.
Yeah, we definitely segregated the
Okay.
TLT tourism stuff. It's right there on the chart. We moved 70% of it into a separate reserve fund and only used 30% in the rest of the budget.
Yeah, still a little bit, anyway.
Okay.
Because there's this other revenues too, so it doesn't say what exactly goes where, so leaves that question.
Okay, any other questions for John? Thank you, John, appreciate it very much. Does Cassie have any comments here? I wouldn't think so.
Good morning.
Good morning.
Can you hear me?
Yes.
Great, thank you. So my only comments to the budgetary issues that you're asking for at this moment is if the Board of County Commissioners moves forward to place the Incorporation ballot measure on the ballot, as well as the council members, then County Council will work through the paperwork to submit to me what I need to do to move forward with that part. And then under ORS 221.061, if this passes, then the city would pay back the election expenses. If it does not, then the county would eat those costs in accordance with what the statute is. And that's about all I would have to say.
Thank you, Cassie.
And we included that.
Thank you.
We included that in the budget.
Okay, so if, again, petitioners are good with us taking a pause and allow you to come back to our next meeting. So Sarah, so we've got 2 additional meetings scheduled for this. Are those going to be enough to take care of what we need to do if we allow this pause here in the petitioner's testimony?
Yes, as long as we would start with the petitioners again at the following hearing and then afford additional oral testimony
Yes. Okay.
before closing the hearing.
Okay.
You just have to make sure the public can respond to anything that's shared.
Okay. And we're going to have to take up the case petition also. Okay. Yes.
If I may.
Yes, please.
When we resume, will you have concluded with the financial portion of your presentation?
Unless you have questions.
Okay, I do. So my question is about short-term rental, and I appreciate the specificity you provided and the information about, the remarkable information about the increase of short-term rental is interesting. And my question is that I have been following this movement since its inception to the extent that it was available online. And a lot of the early rhetoric was about reducing visitor impact, about reducing the visitors to Oceanside, reducing short-term rentals, taking back the feeling of Oceanside as a community and not a vacation destination. And so, but that isn't reflected in the plan, and it isn't reflected in the budget. It doesn't look like you're going to reduce anything because the budget is built on current short-term rentals. Although I see now that you'll have this big cushion built in if the revenue is actually that much more. But it just didn't line up for me, that the idea that does Oceanside want to reduce short-term rentals, or is Oceanside going to be dependent on the current short-term rental income?
Thank you. It's a legitimate question, and we do go into it in detail in a memo later on, but to hit it head on, shortly before you were elected, as part of my being on the short-term rental advisory committee, Oceanside conducted an extensive survey of itself on short-term rental issues. And what the biggest problems were and what people's attitude was towards bans versus addressing the conduct issues. And the survey was remarkable for the lack of support for bans. That is not our community's, there are some local people, but if you read closely what they're saying is I want these people to control their visitors. Not that we don't want visitors to come and enjoy Oceanside's setting. Now, that's a broad statement, but I've been the president for 5 years. I've gotten most of the short-term rental complaints through me, and both as a member of the county committee twice, and as a very, we have lots of communication in Oceanside, and everybody, all the stuff comes to me at OceansideFriends.org. And I was going to include this in my presentation, but my confident and strong sense is that while there will be a group of people that wants to eliminate short-term rentals, I think it's about equal to the folks on the other side that don't want people interfering with my property rights at all. And almost everybody else in the middle is, let's just do something about the problems. If someone would answer my complaints when I do a phone call, then I wouldn't have such a problem with the short-term rentals in my neighborhood. So actually one of the advantages of Incorporation we see is that we're going to be able to create that local response. I'm not saying we want to address caps, we want to, I think we want to address transferability. I suspect we will. And it will be local imperatives rather than the countywide. You're having the same conversation countywide. We'd like to have it locally, but it is not my sense at all that there is a strong movement to get rid of or absolutely reduce the number of short-term rentals. It's more about the problems they cause. We're actually in the middle of taking another survey on that issue. And so if that's available at the next hearing, I'll share it with you.
Thank you.
And I do have one more financial question, so if we want to continue this or if we want to continue it.
No, if we have questions, I think now's the time.
Okay, so financial.
Question or not?
Short-term rental operator fees, so when the county is doing that, we have that tagged specifically for housing and public safety. Is that going into your general fund or is that tagged for something specific?
It's going into the general fund, but one of the items we think that's going to be most likely the city council will. Remember, we're just here with the tax rate and a big number and offer one way to divide it up. City council's going to decide how to, but it has always been my thought when I discuss it with people, my assumption that that's the money that's going to go to code enforcement, to visitor response.
Okay.
So that if the number of short-term rentals went down, so would the need for them.
Okay.
So.
So I have a follow-up question also. You talked about growth concerns, which is great. There have been questions about your revenue keeping up with expenses because of the current economic conditions. Inflation's running 8.5% or higher. Cost of asphalt is through the roof. How long this is going to happen and continue, no one knows. Do you have concerns about current economic conditions and your revenue versus expenses in the near future?
It's a great question. I thought about, it lets me make a point. There's this tough line that the courts draw on your job between looking at the feasibility of the proposal and the wisdom of its future, for the future, its viability for the future. And there's a reason we think what the statute only requires us to offer you 3 years, a first and third year budget. We think that puts some constraint on the scope of what goes into not whether you're approving incorporation, but whether you're allowing a vote. We'll be making that point again to the viewers.
Yep.
So to some extent, the more you try to go into the future and predict stuff like that, I think the more you're going away from the issues that the statute assigns to you, and more into the issues that the statute assigns to the voters on the ballot. So that's with all due respect, that's a tough line, and we're not going to say gotcha or stop that. It's just that line does exist.
And that was not a gotcha statement, gotcha question. These are concerns that I'm hearing in testimony from the public.
We would be irresponsible if we didn't have some concern about that. By the very same token, 2 years from now, the economy could drop off a cliff. People will still be coming to short-term rentals. we're not an income thing, situation, but there are all these, and we don't have income tax, but there are all these variables that nobody can guess for the future, and the statute doesn't require us to try to anticipate everything. I will say once again, if those short-term rental numbers are right, and even last 3 years, that's an extra $80,000 a year in budget. In the general fund budget, not including the TLT tourism facilities, 30% of that increase is going to be $80,000 a year. We're not counting on it, but weighing the probabilities, it appears it'll be there for at least a couple of years. So in terms of the next couple of years of economic uncertainty, again, does that provide a potential buffer?
Fair. Okay. Any other questions?
I would just call back to fiscal year number 1, transient lodging tax of $126,000, which means you get $37,800 of that in your general fund.
No.
Okay.
Oh, yes, I'm sorry.
That's your general fund.
That's right.
You have $10,000 for office rent, equipment, supplies, et cetera. You have $10,000 for insurance and $30,000 for professional services. So we're up to $50,000, plus we need to pay for the election at $6,000. So if you are in fact using those short-term rental operator license fees for something else, your first year budget, there's not enough money to pay for your expenses. So that was related to my question of, can we see a fund balance sort of deal that says, no, really, it's okay, because in year 1, you don't have enough money for your expenses in what you said you're going to use. So does my question make sense?
Right.
Okay.
I think that in that first year, we don't anticipate that the operating dues, are going to immediately be dedicated to a single. We can't.
Okay. So, and that was the nature of my question, was
Yeah.
if you were
The city
dedicating that,
council's
you
gonna-
don't have enough money for everything else. So I will state again, if the record is open in the next hearing and you want to provide a fund balance budget, well, that would be.
I'm going to push back on that, County Commissioner.
It's your choice.
I will
It's your
do
choice,
that,
Mr.
but it
King.
won't be binding on anybody. It'll be a hypothetical exercise.
Sure.
I just move numbers around, and it won't, I don't think, have any relevance to
It's
the
entirely
decision.
up to you. I'm letting you know that I have a pending question. It'll be entirely up to you whether you choose to provide information to answer
I
that.
respect that. Some folks in the community have been led to believe this is an accounting exercise, and the way to oppose a petition is to challenge our amount for roads. It's like, challenge the amount for roads that we started with when the city council puts it in and out of hearings, and maybe they'll put more in.
Sure.
It's, so.
Yeah, and since I'm responsible for determining if it looks like a feasible budget to me, as a person who's worked in fund balance for years, I have fund balance questions. I have whether or not this really can kick itself off and work, because are things going to arise? So a fund balance budget would just help me put that to rest. But again, it is your decision whether you wish to put my question to rest or allow feasibility to float for me.
If I may, Commissioner Scar as well, I think there is evidence in the record, Dave McCall, expert testimony that has looked at this budget and finds it feasible, so I think that's.
It's entirely up to you all if you wish to put my question to rest or if you wish to push back. That's you. I'll end with that.
Thank you. Any other questions?
Not right now.
Okay, so the petitioners are okay with us allowing them to come back at our next meeting, and we'll start the next meeting. So I do notice we have Chris Landy and I thought Denise was on. I just want to ask if so Chris Landy, Director of Public Works, and Denise Vanderkoopering with tax and assessment. I just wondering if you had any input at this point, either one of you. Chris, I see you're on.
No additional input at this point. When I ran projections out there, I ran at 3% inflation. The applicant, Oceansiders, almost doubled what my recommendations were based on our previous maintenance. That did not include local access roads, so they have added some additional roads, but who knows what inflation is. And we ran it at 3%. They went a much heavier budget, and as well as adding a few more local access roads to the system. And they are eligible for additional funds that the county is not eligible for, such as small city allotments.
Yeah. Okay. So Chris, with your comment there, I think you're telling us we need to be very careful and watch our budget closely, right?
Diesel, we spent 2 months worth of diesel in a single month as far as cost goes. The road department budget is, we're concerned.
Giving you a bad time, Chris. Denise, do you have any comments at all?
Good morning, everyone.
Morning.
I have nothing to add other than Mr. King did ask me to look at the spreadsheet, and I verified and asked if I would verify the numbers and if there was anything that he might be missing. And I verified the numbers. I think their logic is valid, and I didn't see anything that was not right. And, you know, the spreadsheets were provided by my department where the calculations came from. So I think we've done what we can.
Thank you very much, Denise. And so since we are going to continue the petitioner's testimony at the next meeting, I'm hoping most of you can join at our next meeting also.
I plan on it. Thank you.
Thank you so much. So I do see Under Sheriff Matt Kelly. I don't know, Matt, if you have any comments at all? Probably not even listening, it's just on. Okay,
I'm listening, I couldn't get my mic, but I don't have any comments, no, sir.
Thank you, Under Sheriff Kelly, I appreciate it very much. Okay, we're going to go into public comments, and we're going to start, so we'll open the public comment portion of this public hearing, and we're going to go to David Phillips first. So David, how long do you think, so public comment is going to be limited to 3 minutes each, but David, I want to allow you time to make your points. How much time do you think you're going to need there?
I believe there are two individuals that would like to testify with me. I'm going to spend as much time as it takes to cover the questions that I see in the record, and then I'm going to let these folks follow me. And as Planning Director Atcher would recognize, you know, as more materials come into the record, then I would obviously have the opportunity to respond to those, both orally and writing as necessary. And thank you for continuing your presentation. I'll take that time now.
So are your guests on our sign-up list?
Yeah, we made the list.
Yes, they are both here and on the list.
Okay.
Would you like for them to go first and then me follow up those questions?
Since you're at the table, let's start with you.
Thank you. I'll go from this point. And thank you, Commissioner Starr, you raised a question earlier about, that raised title questions about whether or not covenants would stay in place to the extent community boundaries or an inclusion of incorporated boundary changes. The truth is, real estate law doesn't change when municipal boundaries change, as we all know. County Council will recognize that as well. And so I want to kind of take off from that question as it applies to federally protected and state law protected takings for landowners who own undeveloped lots in the case. We want to make it clear that to the extent this city gets up and running, we actually don't take issue with the city itself. We do take issue with the city including the Capes as in being part of the incorporated area. And there's a very specific legal question that is pending here that I think was just overlooked in the process. And that relates to this map question that is certainly before the commissioners. What area should be included for what reason? And we understand those reasons are generalized benefit. The context of the definitions that came out of that Oregon Supreme Court case relates to there must be a causal link between the inclusion of the property within the proposed city and the realized benefit. And the benefit must to some degree be able to be realized or appreciated by discrete properties. In other words, we can't just look with broad brush strokes at an entire area. We have to actually look at the property to be considered to be included as whether or not that particular property, or even down to the lot level, could benefit by inclusion into the city. And that raises this big question. It's been assumed thus far that if there are, and there are, undeveloped lots in the Capes, I believe there's 33 of them, correct? Those lots were platted decades ago under state law and local law, your own ordinance. At that time, the decision was made and the planning decision was made to provide sanitary sewer to them as a condition of platting. So that right on the part of the landowner doesn't go away under state law under local law and federal takings law. So we can't assume that a lot owner in the Capes gets a benefit taken away and then added back by inclusion in the city. And that's why the bigger question here that we have is why include the Capes? We don't see any benefit to be included in the city at all. We already receive water services, we already receive and are eligible under state and federal takings law and our agreements with the local improvement district, the sewer district, sanitary district, for sanitary services. And our roads are already built. They're private, we don't need the services. So I don't sense that there's anything in this record or that possibly that the applicants could offer to the record that would provide an ascertainable benefit for the properties within the Capes for inclusion in the city. In fact, their response to our petition essentially conceded that there might be even a marginal or no benefit whatsoever. And that's why this legal question about the sewer availability and that right on the part of the landowner to have the right to hook up to available services as a condition of platting, which occurred many decades ago. I understand that local control might look or sound like a land use benefit, but the county already provides that service to the Capes. We're already comfortable with it, and I don't see, in fact, I see a detriment because our the Capes tax rates would go up for the same service. Same is true of the roads. We already have our own private roads. We don't need assistance from the city to somehow improve our roads where they're all private in the first place. Same is true of emergency services. The county is, from our perspective, is already providing excellent service. Fire, police, all of the emergency services, and they're already generally available to the public. That brings me to the final question, and it's a two-part question again. It's the goal question that Ms. Absher brought up. The interplay between feasibility of complying with Goal 14 and or Goal 11 when you have a city boundary where a service district is attempting to provide services to properties within that boundary and without that boundary. That raises the question as what happens to the area of NETARs. Do we have to include all of them in the city in order to comply with Goal 11 and Goal 14, or take a goal exception, or not? I see significantly difficult problems on the part of the petitioners to comply with Goals 11 and 14 for that reason. Would you like to take it from there?
Oh, sure.
And I'll, again, interact with
Can you just, and I'm familiar with 19 Oregon planning goals. Can you just give me a quick rundown of Goal 11 and Goal 14, please?
Goal 11 and 14, we briefed, and I apologize, our brief was made available just this morning. It's on page, subsection 2, all the way to the end of our brief through the end of the brief at page 15. And I submit that, according to Goal 11, that the service district, the sanitary district specifically, can't comply with Goal 11 if providing services within and without a city boundary. So, as I understand it, the area of NETARs is also outside the proposed area that we're considering within the proposed incorporated area of Oceanside. And so that's a big question for me, and as it relates to the inclusion of the Capes, because again, we already have a constitutional right to hook up to all of the existing sewer lines, because that was a question already answered in the platting and zoning applications of the decisions to plat those properties.
Thank you.
OAR 660-011-0060 in that section could effectively freeze new developments in NETARs. an unintended consequence of this question. And again, I'm just raising questions that I think need to be answered in the record as conclusively as possible. Thank you for your time and your questions. Yes. Go ahead, counsel, please.
New statute to me, Dave, but it says that in part, the commissioner shall not modify boundaries so as to exclude any land which would be benefited, and it says no land shall be included in the proposed city which will not, in the judgment of the court, be benefited.
Correct.
So you're saying your position is that it won't be, your clients, the Capes, will not be benefited.
That is correct.
Okay. And the linchpin is because those undeveloped lots are still going to be eligible to hook up to sewer.
Have a permanent right by virtue of the plat.
Okay.
An unalienable right that's
Okay.
associated with the title
Okay.
of those lots. Generalized benefits don't apply in this case. We have to have an actual. The big ones, access, sewer, water, we already have those municipal services.
Thank you, David.
Commissioners,
Thank you. And you want to bring up next?
If you do.
Come on up.
Yeah.
Please introduce yourself.
Okay, my name is Gene Mitchell, and I'm here for the Capes HOA. I'm the president of the Homeowners Association. I don't know how familiar you are with the Capes. It was actually platted as a development in 1992. 185 lots are there, 152 homes have been built. And if you look at the platting, just what Dave was saying, it was all with the understanding that the sewer and water districts would apply to the Capes. And so everybody's hooked up to sewer and everybody's on water and we have electricity and so on. The Capes, as a development, is subject to the CC&R there. And so we kind of self-govern ourselves. So we have a board, the Homeowners Association, which is elected by the homeowners. They are in charge with enforcing the CC&Rs and also maintaining the Capes itself. To do that, we have the board, we have various committees that may be of interest to you. One is the Architectural Review Committee. So we set our architectural standards as to what can be built and what cannot. We have a landscape committee that takes care of the grounds and interacts with the owners to beautify and keep certain standards within the Capes itself. We also have an emergency committee that takes care of, their focus is what are we going to do in the event of emergency. In the last year we had the fire out there. It kind of spurred everybody on. That committee now has funding. We have emergency water supplies, we have emergency food supplies, we have walkie-talkies, we have zones within, we have how you get out of the Capes, where to go, and those types of things. We certainly interact with the NETARTS Oceanside emergency folks there in NETARTS, and we actually run fundraisers every year to support their activities and to buy equipment and so on. We interact with the Oceanside folks because actually if you drive out there, we are a community unto ourselves. It takes a long time for the sheriff to come and it takes an awful long time for the fire to come. So certainly, and sometimes we rely on the Coast Guard to save some of our folks out there. So in any event, that's what we do, and we kind of self-police ourselves. Now, as far as funding goes, we have assessments. So we have a budget every year, and then we have assessments to the owners. And within that, then we reserve for all our capital improvements. And by law, Homeowners Association must establish reserves. And so we do this as a rigorous exercise every year. We have found our costs going through the roof. But in order to maintain the buildings and grounds and roads and access to the beach and stairs and everything else that goes in on it, we then assess the dues. And part of this whole thing, having us go on out and getting expert testimony and so on, is going to impact the dues. But we are adamant, I guess, that we should not be included in this because there's no benefit. We have nothing against Oceanside, Incorporated. And we work with these guys and we all want to get along. But let them incorporate and leave us out of it is what we're asking. And so that's the reason in the first petition, when everybody was in agreement that the Capes wouldn't benefit, we didn't come before you and make any testimony. It wasn't our business. So subsequent after that, of course, the boundaries were redrawn and a new petition issued, and here we are here today. Of course, you folks asked certain questions in rejecting that first petition. And those are not answered yet. And of course, we're not attorneys, although we do have attorneys within the Capes. But other things have come up from our owners out here. And so we see really an increase in property taxes without any benefit, an increase in oversight, new city laws, and although they can say, well, we won't make laws. Well, we all know that bureaucrats in city government make laws. That's what they do. And we're very fearful that all of a sudden it's out of our control. And although one of us may be elected, we have a lot of homeowners that don't vote here because they reside somewhere else. So they're put into a position of almost, and Steve will talk to this, he's very passionate, and it's right. It's taxation without representation. Oceanside cannot guarantee us that they won't put forth a bonding issue of some magnitude that will attack our property. And there it goes. Most of our owners can't vote for it. So I get a lot of negative feedback from my owners as to what is going on here. But in a situation, let me see, other issues that we explored, and of course we're not attorneys, we're not land use attorneys, all this stuff that's gone on for 2 hours here is completely over my head, and I appreciate you taking the time to investigate it all. But from a common sense standpoint, one of the questions is, can a development, the Capes, be partially excluded from a sanitary district? It's unbelievable that we would even think about having all our sewers there for 30, 35 years, 33 undeveloped lots, and then saying, you can't hook up. Okay, well, here we are in a situation, I've got 3 or 4 homes almost under construction. They come to Tillamook County, they get a building permit. Okay? It takes a while to get carpenters and plumbers and everything else, so we've got this stuff going on, and all of a sudden, you can't hook up. Well, what are you supposed to do? Have a septic system? Well, it's my understanding if you're in a sewer district, you are prohibited from having a septic system. That's the underpinning of a sewer district, that you take care of your wastewater. And now all of a sudden the big septics, it doesn't make any sense to us. So we think that question certainly needs to be answered before anything else. I don't know anything about community boundaries, but to me, an incorporation proceeding cannot change a community boundary. It just doesn't make sense to us. In the first go-around, we're were assuming that because the Capes was excluded, and now somehow we're outside the community boundary, that incorporation petition squeezed the boundary, okay? And I don't think you can do that. Now, I'm not an attorney, but we think that we ought to be able to look into that, because now all of a sudden, we're included, the boundaries expanded. Okay, so this give and take, we don't know how anyway, it's very confusing to us. We don't understand why a community boundary cannot have an incorporated area and an unincorporated area. I mean, a lot of folks are in Washington County, and now they have an urban growth boundary, and believe me, I do not understand the difference between a community boundary and an urban growth boundary, okay? But they have unincorporated sections within Washington County that are in a sewer district, and you hook up to sewer. They also have cities, Banks and Forest Grove and so on, that have their own regulations. So we don't see this dichotomy or conflict because, all of a sudden we're kicked out of a community boundary and prohibited from being benefited by sewers that are sitting 10 feet from my property line. It just drives us crazy. Okay. Is the right solution to forcibly annex the Capes into the Oceanside to solve their problems? Oceanside, I think, can self-govern themselves, and they have issues that they want to resolve through this process. We don't have those issues, okay? And so we don't think to solve their issues, you commissioners need to pull the Capes into this boundary. We think almost we're being thrown to the wolves here, and our tax rates are going to go on up, but they get their city. So we personally would like to remain where we are. We're comfortable in self-governing. We like our little community. We don't see the need to have this oversight. So, as such, the Capes is opposed to the petition, and we ask the commissioners to dismiss the proposal or exclude the Capes from the boundaries, which I understand you have the authority to do, or delay the hearings for us to at least prepare and unfortunately hire more experts and hit our budgets and so on, but we're prepared to do that to go forward. If you want to put it on a cash flow basis, 80 cents or $1 or $1.10 forever on our property taxes, we'll present value that money and spend it this way. We don't want to. And we think it's in your power to remove the Capes from the boundaries. Thank you very much. Do you have any questions? I mean, there were a lot of things on the Capes here. We'd be happy to answer them or come back to the next hearing and answer them and go through it.
Thank you for being here, Dean. Appreciate it very much.
Okay.
Questions for
No,
Richard?
all right, thank you.
No? Okay, thank you very much.
Thank you.
And I think it would be good if you were back at our next hearing.
I will.
Perfect.
We will, thank you.
Yeah, okay, thank you. Okay, next up.
Hello, my name is Steve Playstead. I live in the Capes at 405 Fall Creek Drive. I'm a full-time resident and a registered voter in Tillamook County. I've gone over the petition and I focused on the limited number of secondary services that will be provided for the additional taxes collected on my property. Based on the proposed services of an incorporated Oceanside, it's apparent that the Capes HOA currently provides me all those same services. And therefore, we would not derive any additional benefit from being in an incorporated Oceanside. I'm also aware that during the previous hearings, there were discussions on denying benefit for new construction to connect to existing sewage infrastructure inside the Capes, while existing homes would continue to benefit from those same service infrastructures. The new construction hookups to other existing infrastructures like water and electricity were never mentioned in any of the previous hearings. And so the contradictory availability of those services between existing homes and new construction kind of made that argument a little arbitrary and a reason for including us in the new incorporated Oceanside. I'm going to say that I don't believe the Cape should be forced to be part of an incorporated Oceanside whose proposed services will not offer any additional benefit to the Capes. And since this petition is about establishing a city limit within an existing boundary, it doesn't seem to make sense that the Capes get penalized by being denied benefits that our current tax dollars provide us just because we wish to reside outside that city boundary. Thank you.
Thanks, Steve. Questions? Thank you so much. Okay, we're going to go to oral testimony now, and we're going to start with those that have signed up online. Please understand you will have 3 minutes. I will be the timekeeper. Maybe.
It's 11:30, and I would love for the people in the room to be able to testify, and I wonder if the people online will join us next time, because you said that you have to be in Pacific City at noon.
Well, and I can be late. I'm not sure that Sarah, because they've got 2 meetings today. I think if we're late for the first one, I'm not sure that's going to be the end of the world. Are you good?
I'm great, thank you.
Everyone else in the room good if we go past noon? Bill?
Hi, I'm at your service, Commissioner.
First time I've ever heard you say that.
Never disagree.
Okay, so is it okay if we just share word? Okay. So the first one on our oral testimony list is, it's Gene Mitchell, but Gene, you're here in the room.
Right.
So I'm going to mark you off. How about Dave Friedland? Dave, are you with us?
Yes, I am.
Perfect. So you have 3 minutes. Go ahead, please. Could you introduce yourself? Give us your approximate address, please.
Yeah, good morning. My name's Dave Friedland. My address is 2500 Cape Mears Loop, Oceanside.
Thank you.
And the purpose of my testimony is to recommend to the council a rejection or a postponement of this petition until Tillamook County finalizes the short-term rental reforms based on all the work being done by the short-term rental task force. We feel the Oceanside voters cannot make an informed voting decision on incorporation until they fully understand what the county's future direction on STR limits in unincorporated areas is going to be. One of the fundamental factors for ONA's incorporation proposal is local control of short-term rentals within Oceanside. However, if on a countywide basis, short-term rental changes are put in place, it may eliminate this fundamental issue that incorporation was attempting to solve within Oceanside. And it could solve the issue without incurring $250,000 of additional property tax burden on Oceanside residents. Another point, if Oceanside incorporates and unincorporated Tillamook County adopts some STR limits like other Oregon coast counties, then Oceanside could become a magnet or a sanctuary for even more explosive STR proliferation from a revolving door of anonymous tenants. And this is exactly the opposite of what most Oceanside residents want to see when it comes to a livability balance within our community. It's not that we oppose the current number of STRs, but this could create unintended consequences with explosive growth. The other thing that concerns us is the lifeblood of Oceanside city revenue would be an addiction to taxes and fees on STRs. Just the natural tendency of that addiction to the fees and taxes is hardly going to be a motivator to rein in or limit STR growth. So, to summarize, we're pretty much in favor of Oceanside voters eventually having a choice, but now is not the time for the above reasons. And just like to propose rejecting this proposal until the STR committee completes its work and any countywide STR proposal changes are implemented and fully understood by the voters. Oceanside voters absolutely need to be able to compare and contrast what an incorporated Oceanside would look like and an unincorporated Tillamook County would look like when it relates to STRs. So I urge that the council reject or postpone this, and this whole proposal, this whole petition, there's been a false sense of urgency. So
Thank you, Mr. Friedland.
That's it.
Appreciate your time very much.
Thank
Next
you.
up, Susan Hunter. Susan?
Hello, can you hear me?
Yes, we can. Thank you.
Great. I will be very brief. I think I own property at 405 Capes Drive in Oceanside, Oregon. I spend 50% of my time there. I wanted to let the commissioners know, and thank you for hearing my testimony, that our community actually is very concerned about the livability of the area. And to that extent, we have been active in meeting an urgent community need. We alone raised over $65,000 over the last 2 years for the Netarts Oceanside Rural Fire District. And with that money, they were able to buy things that are needed in emergencies, such as wildland fire outfits, pants, coats, helmets, hand tools. They were able to buy struts that would stabilize their emergency vehicles and buy Jaws of Life, which are very expensive. Yes, there's Jaws of Life in Tillamook, but getting it out to Oceanside takes 20 minutes. We also bought drones with that money, or enabled them to do that. Very expensive, but it helps in water rescues and forest rescues. So I just wanted to put a spin on who we are at the Capes, which is we are very community-minded. We appreciate that Oceanside is going to be 100 years old. We plan on coming and helping with the celebration, but we really don't like, I guess, the disrespect, I would say it this way, that with which we have been treated by not having a face-to-face meeting and being included in their planning process. And that's all I have to add.
Thank you, Susan. Appreciate that very much. Next up is David Phillips. David? Oh, sorry.
Already?
You're on this list also.
I promise I won't go again today.
Sorry. So Stephen Plaisted is also on this list, so we'll get rid of that one. Cheryl, is it Jonas? Jones. Cheryl? You're almost there.
Control. We can hear you.
Just talk, Cheryl.
Yes.
Cheryl, you just muted yourself.
My machine would not unmute, I'm sorry. Can you hear me now?
Yes, we hear you.
Thank you. My name is Cheryl Jones. I live at 370 Fall Creek Drive in the community of the Capes. I'm a full-time resident, and I'm also the treasurer of the association, and I have been since the year 2014. I won't read my entire production, you have that in the record, and Jean and Steve and Susan have covered much of it anyway. I just wanted to say that I'm against the Capes being included, primarily for, well, a number of reasons, but 85% of our homeowners are not full.
Cheryl, I think we lost you.
It goes to the general election. Other than that, I think that just about covers everything. They've already said what I was going to say. So thank you for hearing me, and if you have any questions, I'd be willing to answer them.
So tell you what, Cheryl, since you spent so little time talking, you cut out there in the middle of your testimony. Can you repeat that, please?
We heard you say 85, we heard you say 85% of our homeowners, and I think you were gonna say our second homeowners.
Correct. 85% of them are not full-time and do not vote in Tillamook County.
Perfect. Thank you so much. Okay, so Lynn, do we have any others signed up for online testimony?
No.
No. So we're going to go to those who signed up in-house. And again, we've got David Phillips, Dean Mitchell, Jerry Keene, Sharon Brown. So I take it you don't want to make public testimony here. Okay. Let's go to Robert Alt. Robert.
Yes. Good morning, Commissioners.
Good morning. Again, could you introduce yourself and give us your address, please?
Robert Alt, 165 Reeder Street, Oceanside. Numbers have meanings. There are 3 of you. Probably most decisions you make are either majority or 2/3. I assume there are 950 property owners from the postcards that were sent to the affected area. 83 signed the petition. At the last census, 50% of Oceanside was married, which means about 40 property owners if you figure that out. And that represents just 4% out of 950 property owners. Now, the plan to incorporate only lets registered property owners vote, which obviously means that the majority has no vote. There needs to be a plan to let all property owners a right to vote if it goes to ballot. Otherwise, the majority loses. I'm sure if just one of you makes the final decision, the other 2 would object. This is excuse me, this is exactly what is happening to our majority. Thank you.
Thank you.
Thank you, Robert. Appreciate that so much. How about Kaylee Layton? Layton? Oh. Luton? You signed up. Yep. Okay, not here. Thank you. Sorry. How about, so Ted? Again, I think it's.
Mr. Chairman,
Yes.
we are here, but we did not come to speak. We came to listen and learn.
Thank you very much.
And boy, have we listened, and boy, have we learned.
I like that part about you've learned. That's great. Thank you so much.
Thank you for being here.
Pam Zielinski. Pam.
I'm Pam Zielinski, and I live at 5680 Castle Drive in Oceanside. Actually, I totally agree with Robert Altman. That was pretty much part of what I was going to say, that it really is a small percentage of the property owners in Oceanside who even have the privilege to vote on this, because on the list of registered voters, I counted like around 250 actually separate addresses, which tells me that about 250 people even have the privilege of voting on this issue. And yet there are over 1,000 properties, so you've got 250 households who can now make decisions that will affect over 1,000 property owners, which is truly unbalanced. But one of the things that I want to point out is that what Jerry Keene said earlier about, for example, the attitude of Oceansiders about short-term rentals, is that there is no bias against short-term rentals based on a survey that was done of the 1,000 property owners over here. If you were to put that same question to the 250 privileged voters who are even able to register to vote in Oceanside because they're the ones who live there full-time, if you put that same question to that 250 people, I'll bet the outcome would be totally different. These 250 people have vastly different motives, objections, interests, as compared with 1,000 plus people who either own lots they haven't built on, or they own second homes in Oceanside and couldn't register to vote here even if they wanted to. So these over 1,000 property owners would be putting their futures, their property values, their land use decisions all into the hands of these less than 250 households who have different objectives than they do. So that's my main objection to the whole idea. Additionally, something brought up by the people from the Capes today points out to me that I agree there is no benefit to the Capes to include them, but by the same token, Terracea has their own homeowners association, their own rules, their own private roads, they maintain their roads. Trillium also, which wasn't mentioned earlier, a gated community with private roads, and they take care of themselves. I've been very satisfied with how the county takes care of us in Oceanside, and a lot of my neighbors have said the same thing. And I'll tell you, the thing I look the least forward to is having to take land use questions to a part-time planner for the city of Oceanside. I've worked as a realtor, I worked with enough people who are trying to build, say in Bay City or Wheeler, who have part-time planners. You call and you say, well, you'll have to wait till Wednesday because that's the only day that you can talk to the planner. And if the planner happens to have a full schedule on Wednesday, you might be able to talk to her next Wednesday. So that really delays your land use process. Not only that, it also, it's 3 minutes? Okay, so you can tell I'm against it. I'm opposed to the incorporation in general. Thank you.
Thank you, I appreciate that very much. So the McCaskies are here, they signed up, but do you have any comments to provide?
I didn't sign up to make comments, but if you'd like me to, I'll do it.
Only if you want to make a comment. You're not even in the area, so.
That's right.
Okay, thank you. So Stephen, again, you're listed here, but you've already commented. And we've got one more. How about Blake? Blake Marvis? Morvis? Oh, I'm sorry. Okay, no. So that is the extent of our public testimony. Has anyone else come on, Lynn, that wants to testify?
Nope, not yet.
Okay. So at this point, we're not going to close public testimony, right? Okay. Okay, so we are going to keep the public record open. We're going to start at the next meeting with the petitioners, correct? We will allow public testimony again at the next meeting. Any other business before us? Do you want to recap today, or?
Certainly. So thank you, Chair Yamamoto. A couple of things with respect to the testimony about the Capes. Just to reiterate for the record, the information that you've received is based on conversations staff had with DLCD. I will continue to work through that in preparation for the next hearing. I think it's probably going to be very important. In the meantime, with respect to the map boundary or any other information that you have received today, is there any other direction you have for staff to help you prepare for the next hearing?
I'm sorry, go ahead.
At the beginning of this process this morning, we talked about spending some time with county council and with staff to review the petition to dismiss. So I will want to do that.
Agreed.
That's the important part. Do you have anything that you think you should be working on for us?
I will. Well, that's a lot of questions.
I love doing that.
I can provide additional information with Tom Stiver. If you do have questions about the revenue projections related to TLE.
I do have concerns, so thank you for that.
Yeah, so I will request that he join us in the assembly to talk more about that. Again, conversations had with DLCD were extensive during the last proceeding, and preparing for this one regarding the boundary and benefits. We'll follow up on that. I would note for the record just that because of the timeline that we are on Any change to the map boundary, which again is under your authority to do, will require an additional 2 weeks' notice.
Sarah,
Yes.
only if they want to add people. If
Only
they
if
want
they
to
want to
subtract
add.
people,
Thank
they
you.
have to.
Okay, thank you, Jerry. So just want to make sure that that's also something, just to stay on our timeline with our hearings, and keep the process moving forward, at least on my end, if that's what you would like to see.
So our next hearing is July 13th.
Correct.
And is that scheduled for 2 hours?
I believe it is,
Let's
but
make
I
sure we
do,
have 3 hours for that.
so I will work with Isabel on that, and thank you for the correction on the exclusion. So anything else you would like me to do with the map, any additional information, I will follow up with Isabel. The record is open, everything that you've received today from the petitioners is already online. We have received additional public comments over the weekend and this morning that we were unable to share with you. Lynn and I will work on that, get those to you, and everything received to date will be added to the application page that's not already there. But as we started this morning, everything you received is posted for public inspection. So we will continue.
So in my mind, you've already suggested this about circling back with the LCD about the sewer, but answering the question that Mr. Phillips raised of, do the lots, the undeveloped lots, have a permanent right by virtue of the plat to sewer? That will be key to our decision about the map.
Thank you, I agree. So that's what I will be pursuing with DLCD to follow up on. This option or conversation has never been part of my conversation with DLCD. So I will work with them on that and request something in writing from them with their opinion.
Great.
Okay, anything else? Anybody? Bill? Nope. Joel, anything else?
Nothing at this time, Mr. Chair.
Okay, with that, time being 11:51 a.m., we will continue this hearing to July 13, 1 p.m., back in this same room. I promise we're going to try to clean up this room a little bit. It's a little, it's not as clean as I think it should be, so we'll work on it. So everyone, thank you so much for being here, and we will continue this hearing. Thank you.